Chapter 4, Fair Housing. In this chapter, we're going to talk about the protections of the federal fair housing laws, including enforcement. We're going to describe the protections of the New Jersey laws against discrimination, the LAD, including state regulations on rentals. We'll discuss the implications of the fair housing laws for brokers and salespeople. So we'll start off with equal opportunity in housing. Federal, state, and local laws about human rights and fair housing affect the rentals and sales at every phase of the real estate transaction, from listing to close. And failure to comply with fair housing practice is not only grounds for loss of your license, but it's also an unlawful act. Got a little tip down at the bottom of this slide for you. It applies to basically everything, not just anti-discriminatory laws. It applies to everything, really, even zoning laws and regulations. When there's two laws that cover a same topic, you got to follow the stricter law. The stricter rule will always prevail. Okay? So why do we have fair housing laws? So that everybody can have an equal rights to an opportunity for housing, not equal outcome. There's no guarantee to your outcome in life. A lot of this nonsense has been spread the last couple of years in this country, that we're hearing this word, instead of equality, we're hearing equity. Equity is talking about the equal outcome for everybody. There's no guarantee for the outcome in life. You get out of it what you put into it. You have an equal rights to the opportunity. And that's what a free country like the United States has for us. Everybody has that opportunity. Everybody has the same opportunity in life. You know, not everybody achieves the same levels of success, because you get out of it what you put into it. And people who don't, they're just making excuses. So you have a free opportunity, equal opportunity to have a place to live, whether it's you're owning or you're renting. Not everybody's meant to be a property owner. You know, ownership of real estate, lot more money involved. You know, you got to pay the taxes, you got to pay the maintenance. There's a lot more involved there. If you've got a very low income job, it may be out of your economic reach. So not everybody's meant to be a homeowner, but hey, everybody has the opportunity to own a home. You don't make enough money? Well, get a better education, get a better job, and then you could get a place that you could own. Everybody has an equal right to be able to own the personal property, like the clothes on your back, right? We don't live in times of slavery anymore, where you don't get to own the clothes on your own back, okay? Things have progressed and changed a lot in this country over the years. And there is no freer country than the United States. If there is, I defy you to tell me where it is. Violating these laws is a criminal act. So, it all started back in 1866. What significant thing happened in the 1800s? Who was the president back then that did a major changes in this country that had to deal with equal rights and civil rights? Little history lesson for us here. Remember Abraham Lincoln, the Emancipation Proclamation, right? So let's do a little history search here. The efforts of the federal government to guarantee equal housing opportunities to all U.S. citizens began with the passage of the Civil Rights Act of 1866. You should get down these highlights, by the way. This law is an outgrowth of the 14th Amendment of the United States Constitution. It prohibits any type of discrimination based on race, and or color. It said that all citizens of the United States shall have the same right in every state and territory as is enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold, and convey real and personal property. Okay, so who's the protected class in the Civil Rights Act of 1866? Race and color. And what kind of property did this deal with? All property. There's only two types of property on this planet. It's either real estate or it's personal, like the clothes on your back, right? So you either own real estate or personal property. So it covers all property. So this law, we're going to go over several different civil rights laws, the anti-discriminatory laws. We're going to need to know who are the protected classes and what kind of property does each of these laws cover. So the Civil Rights Act of 1866, just think back, way back then, what happened? We had President Lincoln. Lincoln freed the slaves, and he said that everybody is a human, everybody has the right to own real property or personal property, like the clothes on your back. Okay? So, because of the reference to white citizens, this law has been widely interpreted to prohibit discrimination based on race and color. And when it comes to this law, there are no exceptions to it. When it comes to race, there are no exceptions to the law. Because we're going to go over some civil rights laws that actually have some exceptions to it. And because we have multiple laws that cover the same topics and the same protected classes, because one has exceptions to it, you have to follow the more restrictive rule, which is the Civil Rights Act of 1866. When it comes to race, there are no exceptions. You cannot discriminate based on race. So in 1968, the Supreme Court, there was a decision of Jones versus the Alfred H. Mayer Company because there was a Civil Rights Act movement in 1968. If you guys may have read about that or heard about that in school, you know, the Civil Rights Act of 1968 was a whole swarm of laws covering civil rights. Everything from doing away with segregated schools and segregated bathrooms and segregated, you know, where you could sit on the bus and all kinds of things of that nature, right? There was a section of that law that pertained to housing, and that was the Fair Housing Act of 1968, which fell under Title 8 of that whole embodiment of laws. It was known as the Fair Housing Act of 1968, and it has even more protected classes in it. However, there are some exceptions within that body of law. But because there's exceptions, it doesn't mean that you got the green light to discriminate on someone based on their race or color, because it always falls back on the older legislation, the Civil Rights Act of 1866, that said anytime it comes to race or color, there is no exceptions to the law. Okay. And that was solidified with the court case in 1968, where there was Jones, who was an African American. He sued the Alfred H. Mayer Company, who discriminated against him because of his color. They figured that because the Civil Rights Act of 1968 had some exceptions to the law, that they had the green light that they could discriminate if they don't use a real estate agent or if they didn't use discriminatory advertising. However, the court case proved otherwise. Even though those were the requirements in order to have the exceptions, it also fell back on the Civil Rights Act of 1866, that this court case said that when it comes to race or color, there are never any exceptions, despite what another law says. So This case affirmed that the Civil Rights Act of 1866 prohibits all discrimination in private and public sales in the sale or rental of property. When race is involved or color, there is no exception to the law. So remember what I said. When two laws cover the same topic, the more restrictive rule will always prevail. And that's a perfect example of it right there. All right, everybody got these highlights? All right. So the Civil Rights Act of 1866, once again, is a part of the 14th Amendment of the United States Constitution. It grants equal rights to all citizens for ownership of both real and personal property. That's all property. There is no other kind of property. So when it comes to race, there are no exceptions to this federal law. Okay, so I spelled it out clearly on this slide. Now, all types of property covered by this law are all real estate, both residential as well as commercial. That includes unimproved land. And personal property are things like the clothes on your backs and your personal belongings, your jewelry, your photographs, your money, your car. All that stuff is personal property. Anything that's not real property, real estate, is considered personalty or personal property. Okay, the protected classes are race and color, but there was an amendment to the Civil Rights Act of 1866 in 1987, where they added ethnicity and religious groups to the protected classes under this law. So, when it pertains to the real estate, enforcement for the real estate provisions under this law are enforced by HUD. That's the Department of Housing and Urban Development. So the violations under the Civil Rights Act of 1866 must be heard in federal court, and the statute of limitations is determined by state law on these lawsuits. Federal court has no monetary caps on awards or settlements either. So now let's get into the Federal Fair Housing Act of 1968. What kind of property do you think that the Federal Fair Housing Act covers?
Residential housing.
Boom. Residential, because houses are residential. Doesn't cover commercial property. This law is specifically for housing, for residential property. It's got the word housing in it. That's a little clue so you can remember it. So if you see this on exams, you see the title, Federal Fair Housing Act, you know it deals with residential property. So the Federal Fair Housing Act of 1968 is contained in Title VIII of the Civil Rights Act of 1968. Oh my God, it sounds like there's so many different laws. No, there isn't. You got the Civil Rights Act of 1968, which was, like I explained, it's a whole body of laws that dealt with a lot of civil rights issues, like segregation issues. Now, Title VIII of the Civil Rights Act, that's a section within the Civil Rights Act of 1968. It pertained to housing. And that Title VIII is also named the Federal Fair Housing Act of 1968. So it's the same thing. Title VIII and the Federal Fair Housing Act of 1968, it's the same thing. It's the section within the Civil Rights Act of 1968 that covers housing. And it prohibits discrimination on the basis of, watch, there's more protected classes here, race, color, religion, national origin, that includes the origin of your ancestors, or sex when selling or leasing residential property. So these are, there are 7 protected classes under the law. Race, color, religion, national origin, and sex, and disability. They don't have disability in there yet because it's coming up. They're going to show you that there were some additions to this law later on. So actually, sex was an additional later on as well. So it deals with selling or leasing residential property. Okay. So here's my slide. The Federal Civil Rights Act of 1968 has a section dedicated to housing called Title VIII, also known as the Federal Fair Housing Act of 1968, and it has some exceptions to it, some exemptions. So hopefully this sentence cleared things up with all these three different names. The Civil Rights Act of 1968 and Title VIII and Federal Fair Housing Act of 1968. People often get confused with this, but the Civil Rights Act of 1968, once again, is the whole embodiment of the laws of the Civil Rights Act. Title VIII is a section that pertain to housing, which is also known as Fair Housing Act of 1968. The type of property covered under this law is residential property, whether it's for sale or lease or transfer, and that includes vacant land for residential use. The protected classes are race, color, religion, national origin. There was an amendment in 1974 that added sex because women were being discriminated against. They were spoken down to, like when they go to get a loan for a car or a house. They'll say, "Okay, little lady, why don't you go home and get your husband to come here so that the men can do the negotiations?" Okay, that's the way it was back then. Okay, but things have changed because in 1974 they passed a law that said you cannot discriminate against women like that. So that's what sex, when it comes to sex, there was no word gender back then. Gender, the term gender, actually, it may have been around, it may have been around 1976, I think, that the term gender was invented by a professor in a college, that he was writing hot topic, he was writing controversial books. And he was trying to push people's buttons, and actually started this whole craze back then in the mid to late 70s. We never had the word gender. It's a made up concept. It was only sex. There's two sexes, male and female, right? Now that he invented this concept, gender, now people are saying, we see what's going on in society right now. Oh, there's many genders. You could make up your own. I could be a furry, all kinds of nonsense like this right now. And no wonder why people are confused. All right. So, but either back then, so this sex was a law that was passed in an additional protected class that protected women. And people with disabilities was also added in 1974, including those that have AIDS. It also has familial status. That was added in 1988. That's familial status is people with children, minors under the age of 18. This includes pregnant women that also get protected for being, pregnant. You can't discriminate against a woman because she's pregnant. And it also includes foster families and adopted children as well. Alcoholics and persons in drug treatment programs are considered a protected class under federal law. But it's really weird if you look at the wording that our politicians are doing right now. They're really kind of trying to pervert the laws a bit. But the way that they do it, in this law, alcoholics and persons in drug treatment programs are a protected class. But you notice the way the politicians are writing a lot of laws now, they're saying, yeah, but you can't check or verify that somebody's in a drug treatment program. It's the weirdest thing. Anyway, current drug abusers and people who pose a threat to the health and safety of others are not a protected class. I guess that's why politicians right now are trying to write local laws that say, well, you can't require drug testing, or you can't ask if somebody's in a drug treatment program to prove that they're a protected class, I guess, because current drug abusers and people that cause a threat to the health or safety of others are not. And it's the weirdest thing that politicians out there, it seems like, for some odd reason that I certainly can't figure out, I don't know if you guys can, why politicians would be out there trying to protect drug abusers and drug dealers and people who pose a threat to the health and safety of others, especially since they spent so many years crafting laws to protect law-abiding citizens from these people that can, cause harm to your children or your family or you. Enforcement is done by HUD. the Department of Housing and Urban Development. They enforce all the federal laws when it comes to housing. Now, under the Federal Fair Housing Act of 1968, you have 1 year to file a complaint and have it heard by an administrative judge within HUD itself. HUD has their own judges that all they do is listen to discrimination cases when it comes to housing. But if you go over a year, or if you rather have it heard in federal court, you want to make a federal case out of it, you have up to 2 years to file the complaint. And there are no monetary caps on awards and settlements in federal court. Okay, so this is basically the gist of everything that I'm going to be having you highlight. So this is not a bad slide, again, to snap a photo of. Because for this law, it's spread out across 1, 2, 3, 4 pages. Oh, change it. If you want me to go back, I'll go back and you can snap a picture. Otherwise, we're moving forward. So do these highlights and write these notes in the book. And then I'm going to go to the next slide, which has these same bullet points, except I tweaked the explanations in each of these bullet points to be a little bit more explanatory and clearer for it to be easier to understand. So 1, 2, 3, 4, 5. The fifth bullet point down, you're going to highlight the protected classes, which are race, color, religion, national origin, disability, familial status, and then add sex in there too. And at the end of that line, write blockbusting / panic peddling, because that's what that's known as. And then at the end of the next bullet point, write the word redlining. It's one word, redlining. And then we'll go over all of these discriminatory acts that are covered under the Federal Fair Housing Act of 1968. Everybody good? Everybody got it? Anybody need a minute? Okay. So here's the slide that I have. It's the same bullet points. It's just I gave a little, you could even follow along and read what it says in the book versus what I read right now to see the tweaks that I made to it, the slight tweaks I made. Okay, so the Civil Rights Act covers dwellings and apartments as well as vacant land acquired for the construction of residential buildings and prohibits the following discriminatory acts: refusing to sell, rent, or negotiate with any person, or otherwise making a dwelling unavailable to any person as a means of discrimination. Changing terms, conditions, or services for different individuals as a means of discrimination. Practicing discrimination through any statement or advertisement that restricts the sale or rental of residential property. Representing to any person as a means of discrimination that a dwelling is not available for sale or rent when in fact it is. Or making a profit by inducing owners of housing to sell or rent because of the prospective entry of persons of a protected class into a neighborhood, particularly based on their race, color, religion, national origin, sex, disability, or familial status. This is known as blockbusting or panic peddling. Basically, you're trying to spread panic and fear because these people are moving into the neighborhood. Fill in the protected class where it says these people, and they create a fear-mongering story trying to scare you into selling your home because these people are moving into the neighborhood, and then they, fill in a scary story. Um, and then they're going to drive down your values. So sell now while you can. So they're trying to get you to bust up the block by by panic peddling, spreading their fear of the protected class of these people, whether it is based on their race, color, religion, national origin, sex, disability, or familial status. Now, in the past, it was widely done more based on the race and color and national origin. Um, you didn't see it as much based on sex. However, disability, that's more of what you see it on these days. Um, Here, let me give you a little fear-mongering example. Did you hear what they're going to do with the house next door to you? They're going to turn that into one of those homes for the mentally disabled people, and you're going to have all these crazies in your neighborhood now, and it's going to be dangerous, getting a lot dangerous around here. See, this is the way that they could make up stories and spread fear based on any protected class. You know, uh, these days you don't really see it as much. The discrimination based on race and color, especially in New Jersey. We're a melting pot here. It's hard to find a neighborhood where you don't have people of any particular race or color, right? We're a melting pot. We're one of the most, we are not one of, we are the most densely populated state in these United States. Okay. So if somebody's going to come in and try to say, hey, I want to buy a house and I want you to help me and I don't want to live by these people or those people, first of all, we can't search for homes based on that criteria. That's discriminatory. Second of all, where the hell is that? Right? Um, so anyway, this is known as blockbusting and panic peddling. And even though those names are not specifically in the Federal Fair Housing Act of 1968, they are covered by that law. Altering terms or conditions for a home loan or insurance policy to any person who wishes to purchase or repair a dwelling, or otherwise deny such a loan as a means of discrimination, deny such a loan or insurance as a means of discrimination, even though they can afford it. That is known as redlining. So I guess you could say that redlining deals with the money, right? For mortgage loans or insurance policies. Now, that's not exactly where the term redlining comes from, although you could think of it with the finances. When an application is being denied because of something, you use red ink, right? The financial experts, they use red ink, right, through the application. All right, I guess that's the way that you could try to remember what redlining pertains to: insurance and home loans, even though that's not where they get the term redlining from. I will show you where the term redlining comes from in just a moment. I'll show you a little video that shows you about the residential security maps that banks and lenders and insurance companies used to use as a means to try to discriminate against people based on the neighborhoods. I mean, they got it down to the street, that the streets and the neighborhoods were color coded based on who lived there. Now, denying people membership or limiting their participation in any multiple listing service, real estate brokerage organization, or other facility related to the sale or rental of a dwelling as a means of discrimination. In other words, check me out over here. Look at me. Milk toast, white guy. All right. I could join the African American Association of Realtors, the Hispanic Association, the Asian Association. I'm a guy. I could join Women's Council. Actually, the funny thing about that is me and my ex-wife actually brought Women's Council to New Jersey. So interesting little factoid there. But if I were not allowed in any of those organizations, that would be discrimination under the Federal Fair Housing Act of 1968. Can't discriminate for membership in any organization either. Okay, so let's see, there are some exceptions to the law or exemptions. Some exemptions to the Federal Fair Housing Act of 1968 include the following, but never on the basis of race or color, because it always falls back on the Civil Rights Act of 1866, where there is no exception to race or color. So the sale or rental of a single family home is exempt when the home is owned by an individual who does not own more than 3 such homes at one time, and when A, a broker, salesperson, or agent is not used, and B, discriminatory advertising is not used. If the owner is not living in the dwelling at the time of the transaction or was not the most recent occupant, only one such sale by an individual is exempt from the law with any 24-month period. See, this is that basis that the Alfred H. Mayer Company was discriminating against Mr. Jones there in 1968, where they had that lawsuit that went to the Supreme Court. They tried using this as the basis. They said, well, the Civil Rights Act of 1968, the Federal Fair Housing Act, it said that there's an exemption for me, so I'm allowed to discriminate. And then the judge said, yeah, but not on race or color, because it falls back on the Civil Rights Act of 1866. When it comes to race or color, you cannot discriminate based on that basis. Remember, there's a whole bunch of other protected classes. Now, the rent of rooms or units is exempt in an owner-occupied 1 to 4 family dwelling, and dwelling units owned by religious organizations may be restricted to people of the same religion if the membership in that organization is not restricted on the basis of any of the protected classes there, race, color, national origin, disability, or familial status. They missed sex there again. And a private club that is not open to the public may restrict the rental of its occupancy of its lodgings that it owns to its members. So it's members only, as long as those lodgings are not operated commercially. Now, the 1968 Act later added several more protected classes, which is why they omitted them in those previous sentences that we've been reading, those previous paragraphs, because they didn't add them on yet. So in 1988, mental or physical disabilities was also added. That includes AIDS, people with COVID-19, and all kinds of other illnesses, right? In 1988, they also added familial status. That's family members under the age of 18, including foster children, pregnant women, etc., adopted kids. In 1995, they also added another amendment to the Civil Rights Act of 1968 for housing for older persons. Okay, HOPA. It contained limited exemption to the familial status prohibitions. Why? Because the housing is meant for 55 plus community or seniors. So they don't want little kids running around and screaming in the hallways and such. So there's a limited exemption for the familial status, but that pertains to housing for older persons that's meant to be strictly for older persons. Okay. Now, I told you in 1974 they added sex as a protected class. Well, the 1974 Federal Equal Credit Opportunity Act, ECOA, made it illegal for creditors to discriminate against applicants because of it was based on sex. Of course, they included all the other protected classes in it as well. But this law, ECOA, was specifically made because women were being discriminated against. It had to deal with women, okay? So based on sex. So based on their race, color, religion, national origin, sex, marital status, age, and the fact that an applicant receives income from public assistance programs or exercised any right under the Consumer Credit Protection Act. Women thus had access to more housing opportunities. You see, they just flat out, and they throw sex in there as like a fourth or fifth protected class, when really this law was mainly created specifically to add more protections for women. Now, of course, they're going to add on all the other protected classes to it as well, because you can't discriminate against any of the protected classes of people. But this was actually a major problem in the 70s. This is the way that women were not, they didn't have equal rights as the men did. You know, Alcoholics and persons in treatment are considered a protected class under the disability protected class. So that's where that comes from. That's why alcoholics and persons in treatment, drug treatment programs are considered a protected class. It falls under the disability protected class. So if you could highlight that. But current users of illegal controlled substances are not. It wouldn't seem that way these days. The last couple of years, they've been making everything legal, right? They were even making up places where you could go and shoot up heroin under a doctor's supervision, right? Look in New York, they do that. I don't know if Jersey's got any of those heroin shooting up places, but places like New York and other cities like that, they got them all over the place. And then you see the zombies. You guys know what I'm talking about? The zombies. That ain't pretty. Oh my God! You see these people though; they're just hunched over, standing up. It looks like they're passed out, standing up. That's those are the meth addicts, right? Yeah, that's horrible. I actually seen somebody like that the other day. One of my friends did too. He said, but that person was in a car and it was running. So he's like, I usually don't rat out people. He's like, but that guy's gonna kill somebody. He was in a running car. He's like, so I called the cops, and then he ended up fighting with the cops when he got up, eventually. So the cops pulled him out of the car. But yeah, that's bad. I mean, you guys see it on Live PD and Cops. If you ever watch those programs, you guys see that. You know what I'm talking about. Excuse me. Okay, so other persons who are not considered disabled include persons convicted for illegal manufacture or distribution of controlled substances, sex offenders, and juvenile offenders. Let's see what we got here. All right, so familial status. Once again, familial status, you cannot discriminate against those with families, adopted or foster children, particularly with children under the age of 18, including pregnant women. I don't know if we could say that in New Jersey still, or if they changed the language in New Jersey, if they're censoring it. I know the federal government's trying to. Actually, New Jersey, I think they did change around some of the language where they call them birthing people or nonsense like that, as if a man can get pregnant. That deals with that once again with all this nonsense that comes from the basis of that new created word in the late 70s, mid to late 70s, called gender. So now you got people who are now transsexuals. They're basically, a guy that wants to be a girl that wants to be a guy. So if you have a girl that wants to be a guy, look like a guy, and act like a guy, be recognized like a guy, they're still a woman and they still have woman parts and they still can get pregnant. But you can't refer to them as women because they're not a woman now, they're a man, right? Craziness. Anyway, that's my opinion. There are some exemptions to the familial status protected class in the housing meant for older persons that would be considered as discrimination. Um, that's the senior housing that's meant strictly for those 62 years of age and older. That's what senior housing is. Okay. Both senior housing and 55 plus communities both fall under HOPA. That's the Housing for Older Persons that was passed in 1995. So, what is senior housing? It's 62 and over only. It's housing occupied only by people 62 years of age and older, and posts by entrances that it complies with HUD's rules that the housing is meant for older persons. Now, 55 plus community, what is a 55 plus community? It's if 80% of the units occupied by at least one person that's 55 years of age or older. and the housing facility or community posts and adheres to policies that demonstrate its intent to be housing for older persons 55 and older. All right. See, a licensee marketing housing focused on the elderly should maintain careful records of advertising and conversations with prospects. Yeah, I don't know about that. I guess if you're specializing and doing a lot of that. So HUD got some kind of warning on their site about that. We don't need to worry about that though.
I have a quick question. Yeah, the three exempts from the fair housing are the 62, the 55, and what else?
Wait, for the exemptions for which are you talking about?
The exemptions for the fair housing. It says the 55 plus, the 62, and then what's the third one?
Well, this is the exemption for the familial status requirement. There's two exemptions under familial status, and that is for seniors 62 and older and 55 plus communities.
Okay, maybe it's a mistake in the book. It says there's three, but
Oh,
then
I'm
it
sorry.
only lists two.
Where exactly are you seeing that? So draw my attention to it.
The bottom of 69.
Okay. Where at on the bottom?
With regards to the familial status protection, the Fair Housing Act specifically exempts three types of housing. It's the last section, or right before the very last.
It's only two. That's a mistake.
It's a mistake. Okay.
Yeah. Because then they follow it by state or federal programs specifically designed and operated to assist elderly persons. And then 62 plus and 55 plus. Okay. Well, the state or federal program specifically designed to assist elderly people. Well, that falls within that.
Right. Okay. Just making sure.
Yeah.
Thank you.
So thanks for that notation. Good catch. Let me write it there in my suggestions. See, I've been taking notes. Look at all the notes I've been taking. You know, I got two-sided notes of mistakes and stuff that are in this book that I need to fix or send to them. So this is page 69. Page 69. It's three exemptions. To HOPA. We're ready. All right, so how about this? Can you buy in a senior housing or 55 plus community if you don't meet those age requirements?
Yes, you just can't live there.
Okay. Why do we have 62 senior housing and 55 plus communities? What's the point? What's the benefit of having senior housing or 55 plus communities? What would you think? What would you figure? What would your guess be?
Less taxes?
Yeah, maybe they get tax breaks or some sort of a break on the price because there's subsidized housing for older persons, right? For seniors and older people, tax breaks, things of that nature, right? So why would we allow somebody that's under these age requirements to be able to buy into senior housing or 55 plus communities if they don't meet that age requirement, unless they're a family member that's buying it for their relative who's 55 and older or senior. Wouldn't that make more sense to make sure? Because anybody else, if you're not a family member and you're buying units in housing for older person properties, and you don't meet those age requirements, the only thing I could get out of that is that you're an investor and you're planning on marking up the price to rent to them. Can you think of another reason? So doesn't that kind of defeat the purpose of the housing for older persons? At least that's my train of thought. That's my thinking. I mean, if you guys don't agree with me, sure, express yourselves. If we got free speech here, go ahead, talk. That's what I figured. But I got this question here. I actually posed this question to the legal resource library there that I showed you guys before on New Jersey Realtors website for the legal resource. Actually, this question I didn't, but I posed one similar. Can a buyer younger than 55 years old purchase a property in a 55 plus community if they're going to rent it out to 55 plus tenants and the community allows rentals? Can each individual homeowners association determine a restriction on the age of the buyer? You know, uh, there were actually a lot of municipalities, like I think Matawan was one of them, but there's a lot of municipalities that have a lot of 55 plus and senior housing communities. And they were having a lot of investors purchasing housing units in these areas. So local town ordinances, the local politicians put into place rules that said that they cannot do this. You have to meet the age requirements. Now, they shouldn't have just done it that way. I think that could be wrong, and that's probably why they ended up losing the case, because they should have worded it like I did. Devil's in the details, right? You could be younger than 55 and still buying a 55 plus or senior housing community if you're buying it for a relative, a family member, not as an investor who's going to be marking up the price and then renting it out to the seniors. Kind of defeats the whole purpose of the law to begin with. So on the next slide, I got the answer. Now here's the exact link to where it is on that website. But here, this is as of January 12th, 2024. This was the answer that they had here, that the Housing for Older Persons Act of 1995, permits communities to limit the occupancy of homes within age-restricted communities to individuals who have attained those ages. Similarly, New Jersey law requires that all purchasers or grantees of homes in an age-restricted community certify that homes will be occupied by individuals who meet those age restrictions in the community. But neither the federal or state law requires a non-occupant owner or grantee to meet the age restrictions as a prerequisite for purchasing or obtaining title to property within an age-restricted community. That being said, New Jersey Realtors is aware of some homeowners associations and municipalities that have enacted governing documents or ordinances that require owners to meet certain age restrictions, even if the owner would not be occupying the home. That's where they went wrong, and that's why they lost this court case. I'm already telling you what happened. They shouldn't have required them to be of age. They should have said that they cannot buy if they don't meet those age requirements unless they're buying it for a relative, someone that is 55 or older or 62 and older. Investors who will mark up the price should be excluded. That's the way they should have worded it, but they did not. So, of course, New Jersey Realtors Association only cares about selling homes, and because that's what their whole deal is. So, New Jersey Realtors' position was that HOA regulations or municipal ordinances that prohibited non-occupying individuals under these ages owning home in age-restricted community, even when they certified the occupant will meet the requirements, violate federal and state laws. And for this reason, New Jersey Realtors is currently challenging the legality in court. Well, they did, and they got the answer. Here's the answer: that the matter was decided in the New Jersey Appellate Court in New Jersey Realtors versus Berkeley Township. In July 2024, the court agreed with the New Jersey Realtors that ruled that it is the age of the occupant, not the age of the owner, which matters, and that someone under the age of 55 or 62, as applicable, cannot be precluded from purchasing a home as long as they certify in writing that the occupant will meet the age requirements. See, I think now our legislature should step in and tweak the law that says that investors are precluded from buying. Okay, so you can be under the age requirement to buy as long as you're not going to be marking up the price, because that defeats the whole entire purpose of having housing for older persons. So to me, I think there will be more battles that come with this in the future, possibly. I think there should be, personally. What do you think? Think about it. I'm just throwing some things out there, letting you guys have some thoughts that stir in your head so that you can think it over. Yeah. Now, with regards to the familial status protection, okay, so we already did this. Already read this. We already beat this dead dog. Okay, so housing intended only for 62 and older. I just wrote next to here senior housing. That's senior housing, and one for 55 and over. That's 55 plus communities, but both of them fall under HOPA. That's Housing for Older Persons Act. Okay. Can you live in a 55 plus community if you're not 55 or older?
No.
Oh.
80% of the units must be occupied by at least one person 55 and older. So that tells me that there could be up to 20% that there are not occupied by people that are 55 and older. Now, how could that possibly be? Well, maybe your spouse was 55 and older and they died and they left it to you and you continued living there. Or maybe you're 55 and older and you're there with your child, your adult child, because they do have age restrictions on, they could have age restrictions that you got to be at least 18 years old to live there with your senior parent, So you got 55 and older, and maybe the parent dies and they left it to their child, they can't kick them out. As long as the association maintains occupancy level that at least 80% of the units are occupied by at least one person 55 and older, it's allowable. But you can't be under 55 and buy in there and move into there. That's different. So here is the Housing for Older Persons form that some MLSs, like the Garden State MLS, this is a form courtesy from the Garden State MLS. They want you to certify that it is housing for older persons. If you're going to put age restrictions on who can occupy this property, if you put a property in the MLS for rent, for example, and it's based on an age restriction, that's discriminatory against the familial status requirement. unless you certify and you have it in writing that this is in fact housing for older persons and it's been certified by the housing facility managers and the owner. So if you're going to get a listing in a 55 plus or senior housing community, you need to make sure this form is filled out. Because if you just submit the listing into the MLS without it, you're in violation of the Federal Fair Housing Act of 1968 under the familial status requirement, right? Okay, what about service animals? Can someone not allow you to have a service animal? Well, the Fair Housing Act, this FHA is different than the Federal Housing Administration FHA. This is actually a law. The Federal Fair Housing Act, when they talk about FHA here, makes it unlawful for a housing provider to refuse to make a reasonable accommodation that a person with a disability may need in order to have an equal opportunity to enjoy and use a dwelling. Assistive animals are not pets. They do work. They perform tasks, assist, and or provide therapeutic or ESA emotional support for individuals with disabilities. So you have to consider that assistive animal as part of the person's disability. It's like if somebody needed a wheelchair, you can't say no wheelchairs allowed. Okay. So if somebody has a disability and they need a service animal, assistance animal, you cannot deny them. You have to make what's called a reasonable accommodation to allow them to have that assistance animal because it's a medical need. So there are two types of assistance animals. There's service animals that are trained to perform tasks, and these service animals, technically only a dog can be a service animal. And in some cases, a miniature horse. And then there's emotional support animals, which just having them can soothe somebody, can calm somebody's nerves or mental issues that they may be having. Okay. Just the fact that you have them. So they don't need any kind of special training or anything like that. Service animals, they're usually like guide dogs that lead blind people, or they could sense, they're trained to sense when your blood sugar is running low and you may have a seizure coming on or something of that nature. They're usually larger dogs. Service animals that perform tasks, they're usually not tiny dogs. They're usually larger dogs because they're there to lean up against you and hold you up or to pull you. The little dogs aren't going to do that. So that's why service animals are usually the larger dogs. Now, ESA provides therapeutic and emotional support for individuals with mental health or emotional disorders, such as depression or severe anxiety or phobias. The landlord may not inquire as to the nature of the person's need, only the right to verify that a letter from the therapist is real and that the therapist is licensed and confirms the tenant has a need for an emotional support animal. So in other words, they can't ask you what your illness is. They could just say, is that a service animal and what function do they perform? Or is it a legitimate service animal and we need a prescription from your doctor to have it? And that's what the letter is. That's on the doctor's letterhead with the contact information so that they could contact the doctor. Now, I know there's a lot of these fake websites out there. They get your animal, get your pet certified as a service animal so your landlord can't kick you out or can force you to allow you to have the service animal. We will certify it and we'll even send you a copy of your permit that we'll give you, and they could go to our website and search your permit number to verify that you have a medical need for a service animal. I call bull crap on that. You know why? What do we call that medical privacy law? HIPAA? You guys ever hear that? HIPAA? The medical privacy laws? They can't put your information on a website that anybody from the public can search and see if you have a medical need. That's nonsense. Right off the bat, that should be your first clue. It's a scam. They're trying to sell you all this nonsense, and it's not a real service animal. Okay. It's not hard to get your pet, certified as a service animal. If you have an emotional need, get your therapist to give you a letter on their letterhead that says that you have a need for a service animal or emotional support animal. Or if you have a need because you have a medical need, like you have seizures or you're blind or and you need that guide dog or what have you, you could get a letter from your doctor. Okay, so all that's needed is that letter. And landlord can deny animals that pose a danger to other tenants or who are disruptive or cause undue financial burden on the landlord. Uh, Listen, if you're a landlord and you have animals, or look, maybe you're not a landlord, maybe you just own your own house and you have homeowners insurance. You have to let your insurance company know if you have a dog. You got to let them know because then they're going to want to know, did they have their rabies and distemper shots? Um, and what breed and weight is the animal? Because I know everybody loves their pit bulls and their Rottweilers. I know that they're the biggest little babies, and you got pictures of them kissing and licking and sleeping next to your baby. But I tell you what, when these animals do turn, um, they're dangerous. They're strong. So they do cause a lot of damage. So some municipalities even put bans on certain dogs. Not just Rottweilers and pit bulls. You got your Akitas and all those other dogs too. You got your German Shepherds and a lot of these dogs. I know the Chihuahua that barks and they're so vicious. Yeah, but they're not going to cause any damage. You'd be lucky if they could break your skin with their bite. So they don't pose as big a threat. But are you allowed to have a pit bull as a service animal? There are no breed or weight restrictions. Look, shops, businesses, and public buildings such as courts and libraries are legally required to admit service animals, even if their general policy is that no dogs are allowed. They're not required to accept ESAs, though. The emotional support animals. They're no longer required to be allowed into public areas because you give people an inch, they take 10,000 miles. Everybody loves their pets, but now you get all these people, they take their yappy little dogs into every restaurant or store, and they say it's my service animal. Well, no, it's not a service animal. It's an ESA. It's your emotional support animal because service animals are not going to be there yapping away and snapping at people or running around. They stay close to their handler, their owner. Okay, because that's their job. That's what they're trained to do. Emotional support animals, they don't need any training. They're all over the place. Okay, they don't need to be allowed into these public areas anymore because people took advantage of it. They took their pets on the beach, and then you got your dog shitting on the beach and people stepping in it, or lifting their leg in a restaurant, or snapping at people, or going on public transportation in airplanes. Do you know that airlines, if you have a service animal and you're in a plane, if that flight is longer than I think 2 or 3 hours, the airline is legally obligated to provide a place on the plane where the service animal can relieve themselves. If you got everybody that got their animal that's a service animal, oh my God, we're going to have a messy, smelly flight. Mhm. So I have this is all the book has on this. Do you guys got these highlights?
Yes.
Okay. I went in a little deeper because I always get people that ask me a million questions about this stuff. So I went in a little bit deeper talking about service animals here. The Fair Housing Act prevents discrimination against tenants in their homes. So a landlord would be guilty of discrimination if they violate the tenant's rights. They have to provide what's known as a reasonable accommodation for service animals, which can be assistance animals that perform tasks, or they could be emotional support animals that soothe the mental condition when the tenant has provided a medical professional's prescription for one. Now, under the FHA, the Federal Housing Act, not the Federal Housing Administration, a disability is defined as a physical or mental impairment which significantly limits a person's major life activities. So even if there is a no pets policy or a pet restriction, landlords are required to make what's called a reasonable accommodation to allow pets to serve as assistance animals, which also even includes emotional support animals for residential properties anyway. Assistance animals are in a different legal class than pets who are not assistance animals, which is why pet restrictions and fees are waived for them. So your landlord cannot charge you any additional fees for having a service animal or assistance animal. So these are animals that work, assist, or perform tasks and services for the benefit of the person with a disability or emotional support that improves the symptoms of that disability. There is no official certification for training that you need to get, and they can assist in a variety of ways. And breed and weight restrictions do not apply to assistance or service animals. So, yes, even a pit bull can be a service animal. So, what's the difference between service animals and assistance animals? Well, I told you, service animals can only be dogs, or in some cases, miniature horses. Whereas assistance animals could be those that are trained to perform tasks, but they could also be emotional support. I know this is getting a little crazy now with all these service animals, assistance animals, emotional support animals. Okay. Other way, in residential housing, you have to allow these service and assistance animals. So let's see. What are some examples of ESA? An emotional support animal can be a cat, dog, or other type of companion. ESA animals do not need to be allowed on planes or in public accesses areas anymore. They used to. The fact that the term service animal is often used by landlords and public housing authorities refers to both service dogs and assistance animals, and that's what often creates the confusion. You could have assistance animals like a cat or a dog or some other animal that could detect and alert their companion to oncoming seizures, or they alleviate the person's depression or anxiety, or reduces the person's stress-induced pain. Or you could have a bird who alerts a hard of hearing companion when someone's come to the door and rang the doorbell. They may not hear that frequency, but that bird is squawking and flapping its wings on your shoulder can get your attention. Look at these amazing animals. Look at the ooja booja. Look at that face. How could you not love that face right there? Uh, this is I got a little example here of a service animal in action, notifying its owner that a her blood sugar is running low.
Oh, is it going low? Probably. Let's see.
You see that why they're big animals? Why they're usually the larger animals? A small animal is not really going to get your attention hitting you with their little tiny snout. But a big animal like this, look at him. Look how he's pushing on her.
Oh, is it going low? Probably. Let's see. 105 halfway down. Good boy.
Look at that face. It's these animals are amazing what they could do, how sensitive their noses are. They could smell that her blood sugars run low. And if she doesn't, get her medicine or drink something with the sugary drinks or whatever, the orange juice or whatever it is, that she could end up having a seizure. I think I have another example. Yes, I do. I added another example here. Check out this example. This one is pretty neat. Now, of course, people this I got these from social media, and look, they got their little subtitles under here saying what exactly the service animal is doing. But just take a look. I still want you. Let me turn off that volume so that this video does not get censored when I put it up on YouTube. So I hate when they put music up there like that. So let me rewind this and we'll start this one again here. Here's another service animal that actually senses that their owner is having a medical emergency. And look what he does to help her out. Okay. So she gets up. He tells her to sit down. He senses that she's going to have a medical issue. He goes up, he gets her medicine for her. And then goes to the refrigerator to get her a drink of water to wash it down. And then he stays with her for that. You know, isn't that amazing?
Impressive.
It is. It is. All right. So so the service animals, see, this is why it's a shame when you get people that they try to pass off their pets as actual service animals. It's what emotional support's different, you know. In housing, your landlord cannot deny an emotional support animal either. But in public accommodations, when these laws were initially written, it covered both service and emotional support animals, and people took them everywhere with them in the stores and Home Depot, anywhere you go, and they're snipping at other people. You've got people taking their animals on planes, and they're the fake service animals, and then they go attack actual service animals, you know, and start fights with. There were fights on planes with people and their owners who have these fake service animals. So there ended up being a ban on them. And they got rid of the ESA animals. They're not required to be in public accommodations and airlines either. So how do you demonstrate your pet is a service or assistance animal? You just need that letter from your therapist on their letterhead with their contact information. Now, what do you do if your landlord refuses to accommodate that reasonable accommodation and provide that reasonable accommodation? Well, you file a complaint. They're discriminating against you. So who do you file complaints with? Well, it depends. Are we doing it under federal law? If we are, then we file that with your local Department of Housing and Urban Development, HUD, or the New Jersey State Attorney General's office if you want to do it according to violation of New Jersey's laws, which we didn't get into the LAD. All right, so who is exempt from requiring you to allow service animals or these emotional support animals? It says all types of housing, including public housing, are covered by the FHA, except rental dwellings with 3 units or less, if the owner occupies one of the units. Single-family homes sold or rented by the owner without the use of a broker, or housing owned by private clubs or religious organizations that restrict occupancy in its housing units to its members. So, service and assistance animals are not technically pets, and owners do not have to pay fees or additional rent to have them. The landlord, however, can charge security deposits for damages to any tenant if they have an animal or not. You know, that's the whole idea of security deposit, right? Just don't call it pet security, because if it's a service animal, you're not allowed to charge any additional fees. Okay, so just make sure that it's just part of your regular security deposit. So it's not advised to call it pet security. And in New Jersey, the maximum allowed security deposit by law is 1.5 times the monthly rental figure. If the animal, whether it's a pet or service animal, cause damages beyond that, well, you could always chase after the tenant to cover those. And look at this. There's even a question on the New Jersey Realtors legal diary about dogs and service animals and fees for that. Now, so it covers the same thing that I'm telling you right now. So the owner may still seek money from the tenant if there is damages caused by the animal to the home. Also, if there's a nuisance issue, the landlord does have the right to try to remove the assistance animal through legal proceedings. You got to control your animal. If they're chasing around the neighbors and trying to bite them, no good. So here's that screenshot from that NAR legal diary on it. Is it legal to charge a dog, pet, or animal fee when renting an apartment? So landlords may not charge pet security deposits if it exceeds 1.5 times the monthly rental figure. The maximum security deposit collected by the landlord cannot be more than 1.5 times the monthly rent. It could be less. Any additional security deposit increase collected annually shall not be greater than 10% of the current security deposit. And the security deposit law applies to most residential properties, including mobile homes. The exception is owner-occupied 2 or 3 family dwellings, if the owner is living in one of them. So let's ask this question. How do fair housing laws apply to real-life situations? So here's a real-life situation I have for you. I want to see if you guys can answer this. John's been diagnosed with severe depression, and he's disabled as defined under the Fair Housing Act. His doctor prescribes John a dog to help alleviate his symptoms. John asks his landlord if he could have the dog as a reasonable accommodation for his disability. His landlord says yes, but then tells John he needs to pay a $250 pet deposit and has to provide proof that the animal's trained. So, did John's landlord act correctly in handling his request under the Fair Housing Act? And what if John wanted a cat or ferret instead?
It seems like it was allowed, like he did it right.
Yes.
The answer is no.
What?
John's landlord did not handle the request correctly. The landlord cannot charge John a pet deposit for his animal because it's not a pet, but rather a service or companion animal required for his disability. Can't charge any additional fees. Further, the landlord cannot ask for proof that the animal's trained. You know why? That discriminates against poor people who may not be able to afford the $25,000 or $50,000 it costs to train these dogs. What if they have the ability to train them themselves? I know most people can't even train their dogs not to crap on the floor in their house, but let alone sense if your blood sugars are running low and alert you to oncoming seizures, But the law does not require any specific training from a specific authority, okay? Lastly, the companion assistants or service animals, they do not need to be just dogs. They could also be other animals like cats and ferrets and birds. So before they changed the law on removing, not requiring emotional support animals in airplanes and other public accommodations, I got this news story. So this news story is just a couple of years old. I think this one's from like 2014 or 15 or something like that. It gives you an example of why these emotional support animals are not allowed on planes anymore.
The largest airline to crack down on the so-called emotional support animals since that song. The policy change was prompted in part by a passenger who tried to board a United flight with a large peacock on Sunday. Delta announced similar restrictions just last month. CBS News travel editor Peter Greenberg is at United's hub at Newark Liberty International Airport, and that's where that peacock was grounded. Peter, good morning. Most people don't think of peacocks as emotional support animals.
No, but they are. In fact, more and more airlines are reporting that the number as well as the types of emotional support animals is reaching crisis proportions. Now, we're not just talking, as you can imagine, dogs and cats. In fact, the interior cabins of some flights are beginning to resemble Noah's Ark.
I'm not kidding. This woman is wrangling her peacock into the airport.
United Airlines says it warned the peacock's owner 3 times that Dexter would not be allowed to board.
Dexter.
The bird lives with an artist in Brooklyn who claimed Dexter was her emotional support animal. In this 2016 interview, she described how she found him.
I got him originally for an art project, and
Hold on. Did you guys hear that? It was kind of quiet. She said she originally got this peacock as an art project. Do you think she really needs this peacock for a service or emotional support? Well, I don't know. She looks kind of a weirdo, but the peacock, does she really have a medical need for it? I think it's easy to get these letters from your doctors, and I guess she is visiting a therapist, but
but then this happened, and I was like, do I have a peacock cut blade in my neck?
Yeah.
Yes, I do.
not only does she have a peacock on her neck, it looks like she got scratches on her face from one too.
In my neck?
Yeah.
Yes, I do.
United Airlines already prohibits non-household birds, hedgehogs, ferrets, spiders, sugar gliders, and other exotic animals. Its new policy requires owners to give 48 hours advance notice when flying with a support animal, provide a letter from a mental health professional, and documents from a veterinarian showing the animal is vaccinated and not a threat to the public.
We've had roosters and ducks and pigs and monkeys.
Sarah Nelson is the president of the Association of Flight Attendants and says she applauds the new policy changes.
But what we really need is for the Department of Transportation to act with guidelines for the entire industry.
United saw a 75% spike in comfort animals, from 43,000 in 2016 to 76,000 last year. The critters sometimes relieve themselves in damaged planes. In June,
Look at this, a kangaroo, a pig, a miniature horse, and a duck. A duck or goose, I'm not sure.
an emotional support dog bit a Delta passenger. Can pigs fly? In 2015, we showed how easy it was to get one on a flight. A Colorado counseling center provided CBS This Morning with a letter prescribing the pig as the primary treatment for a psychological disability. Tom Panic, CEO of Guiding Eyes to the Blind, says people are passing off their untrained pets as service animals.
As a person who is blind, my access rights are being infringed upon when somebody passes off a fake service dog.
Now, the new policies for United and Delta kick in on March 1st, and American Airlines is expected to follow suit. But we should note that the new policies only apply to emotional support animals, not the trained, specially dedicated animals that fly for and with people with disabilities. John?
Peter, thanks.
Yeah, people take their pets very seriously. We get it. But you see a lot of people taking advantage of that policy. So I think it's good that they're trying to figure out a way to crack down and make sure that the legit animals go.
Yeah, I think this was actually 2018 or 2019 when where this video is from. But it just gives you an example. So I gave you this further breakdown here for service animals, which can only be dogs or in some cases miniature horses, or those emotional support animals, those assistance animals, the ESAs. These are the new rules on it based on this checklist here. So service animals, they could be allowed in public access, but not the emotional support. Air travel rights for service animals, but not the ESAs. Housing rights, they both have housing rights. So that's where we both come in, right? Trained, well, service animals are typically trained, but they don't require any specific training from a specific authority. Emotional support animals, they don't need to be trained, just simply having that pet. I see Doris is petting her dog over there, little cutie. And, you know, the trained animals, so they don't need to be trained, any specific training, and registered or certified, none of them need to be. A lot of people who get those fake service animals through these websites. They say, oh, we'll certify the animal, we'll have it registered, this could be verified. That's nonsense because there is no certification. Do service animals have to have a harness that they wear? No. Does the owner need to carry a pocket card or license for them, proving it's a service animal? No, they don't. Because these are restrictions that they would put on a person based on their disability. It's like, does a person who's riding around in a wheelchair need to have a card that proves that they need the wheelchair? Yeah, same kind of thing. All right, let's move past that. I want to spend a little bit of time on that because I know a lot of people usually ask about the service animal stuff. All right, so fair housing. HUD requires any business offering housing or housing services to display that equal housing opportunity poster. You guys all seen it, the picture of a house with the equal sign in it. Failure to display this poster is evidence of discrimination. Let me repeat that one more time. You can see this poster on page 71, and I'll show it to you on the next slide. Here, this is what it looks like. Okay. Has that equal housing opportunity with the house with the equal sign in it. Now, failure to display this sign for anybody that offers housing or housing services. Failure to display that poster is evidence of discrimination. Now, intent to discriminate is not a requirement in order to be found guilty of discrimination, only the fact that discriminatory act had occurred. And under the federal law, if you simply do not display the equal housing poster, they consider that evidence of discrimination because you don't advertise that you offer equal housing for all. That must mean that you do discriminate. So if you ever file a complaint against somebody for housing or housing services and they don't have that equal housing opportunity poster there, and HUD sends out one of their investigators, they will look around and they see if you got that equal housing opportunity poster anywhere in the office. If it's not there, they stop their investigation and boom, you are guilty, my friend, of discrimination. The threshold is not that high. The bar is not that high to be found guilty of discrimination. So when HUD investigates a broker for discriminatory practices, considers failure to display the poster evidence of discrimination. So you guys are highlighting this, right? Federal Fair Housing Act 1968 required that equal housing poster. And when HUD investigates, if you don't have it displayed, that's their evidence that you do discriminate. Now, here's something for later on in this chapter on page 86 that goes to show that you don't got to go there right now. We'll highlight this later. The complainant does not have to prove guilty knowledge or specific intent, only the fact that discrimination occurred. So it doesn't matter what your intent was. If they could prove you discriminated, you're guilty of discrimination. That's all it takes. And that's that equal housing opportunity poster that just shows it is illegal to discriminate against any person because of their race, color, religion, sex, handicap, familial status, or national origin. Those are the 7 protected classes under the federal law. So for the sale of housing or residential lots, in advertising the sale and rental of housing, in the financing of housing, in the provisions of real estate brokerage services, in the appraisal of housing, and blockbusting is also illegal. What's blockbusting also known as?
Panic peddling.
Panic peddling. There you go. Good. Okay, so let's highlight those things now on page 72. Blockbusting, steering, and redlining. Even though they're not mentioned by name in the law, they are all covered under the Federal Fair Housing Act of 1968. Okay, Let me know when you got all that. Everybody good? Everybody good? All right. So, Title 8 of the Civil Rights Act of 1968 is called the Federal Fair Housing Act of 1968. And the Fair Housing Act of 1968 makes these practices illegal, although they're not mentioned by name in the law. Blockbusting. These are my explanations of what they are. Blockbusting is sometimes called panic peddling. It's using discrimination as the tool. See, my definition here will definitely explains it a little bit better than the book. It's using discrimination as the tool to play on a homeowner's fears of a protected class that these people are moving into the neighborhood in order to scare them into selling. So they basically create a scary story about these people, which these people is the protected class, fill in the blank. And then they put in a scary story to try to spread panic and fear. And then they'll step in and try to offer to purchase the property from you to be your savior. Of course, they're not going to be able to buy it at the top market value because, you know, these property values are going down because these people are moving into the neighborhood. Okay. So basically, they're a bunch of scam artists, right? And where the heck was it where this started? It'll come up someplace a little bit later on in this chapter, but I thought I wrote it down. I always forget where it is. All right, anyway, it doesn't matter. So steering now is limiting someone's options of where they can live by not showing them all the properties that meet the criteria. Oh, Baltimore. There we go. Came up. So yeah, in Baltimore, I seen a documentary in Baltimore where blockbusting was happening, and they showed how you had these two guys knocking on people's doors, going door to door, knocking on people's doors, saying, "Hey, listen, these people are moving into the neighborhood," and they were talking about people of color, and they were like, "They're going to drive down your property values. Your property's going to go to crap. You got to sell now, but we're willing to buy it from you, but of course we're not going to pay top dollar for it." And then they buy the house, and then they turn around, they sell it or rent it to the very protected class that they were building the scary story about at, of course, a marked up price to make money. And they even went as far to pay a young girl of color to push a stroller down the street while they knock on the door, and then they could be like, "Look, it's happening already to your neighborhood." You know, so they pull up these scary stories, and then they're even paying a young black girl to push a stroller down the street while they're knocking on the doors. So they're all part of the same scam to scam people, and it's a crazy thing. That documentary, I'm trying to find where the hell it was. That was something, so I could put these clips in here. So steering is limiting someone's options. This is something different. Steering. Who do you drive around in a car as a real estate agent? Who do you drive around? What kind of clients do you drive around in a car?
Buyers.
Buyers or renters, right? You're driving them from property to property. So this is discrimination against buyers or renters. Okay, blockbusting, you're trying to bust up the block by spreading scary stories. Okay, so that's discrimination. It's discrimination against the homeowner. You're playing on a person's fears by building up this scary story to try to scare them into selling their house. Okay, so blockbusting is discrimination against the homeowner. Steering is discrimination against the buyers or renters. Now, how do you discriminate against buyers or renters? Well, by limiting their options of where they can live, by not showing them all the properties that meet their criteria in the price range that they could afford, and that they're looking in, by channeling home seekers to or away from certain areas, simply by not letting them making them aware that homes are available in those areas, or you could limit their options by not showing them homes, or you could say, you know what, I think you'd like it better over here, or this neighborhood is nicer over here. Basically, you're the one that's making the decision where somebody should live, either by trying to steer them in one direction, by trying to convince them to go over in one area versus another, or by limiting their options and not showing them properties that are available in the areas that they're looking, not even letting them know that they're even available. So when the agent's the one who decides where the buyer or renter should live, that could be deemed a discriminatory act. It doesn't matter if your intentions are good, by the way. Because remember, when it comes to discrimination, intent is irrelevant. The person just needs to prove that a discriminatory act had occurred. Now, redlining is refusing to give financing or mortgage loans or insurance policies, even though the person can afford it, as a means of discrimination. Actually, we did all these highlights before, but actually this one page here is pretty good for a snapshot for the definition of these three things to study. It gives you everything you need to know about blockbusting, panic peddling, steering, and redlining, if you want to snap a picture of this slide or snap a screenshot. Everybody good? Okay. So here's where the actual term redlining comes from. I got this from a clip from a documentary about civil rights movements and such. And here is a documentary talking about, I took this clip talking about redlining and where that term actually comes from. It's actually got some pretty interesting stuff in it here too. Let me take off my camera and minimize everybody so this plays right.
In the 1930s, in the wake of the Great Depression, FDR is president. He wants to bring economic relief to millions of Americans through a collection of federal programs and projects called the New Deal. One part of that New Deal was the National Housing Act of 1934, which introduced...
The interesting thing is politicians, just in this last couple of years, they keep bringing up the New Deal. Remember during the Biden administration, they kept talking about he wants to do a New Deal. Well, check out this original New Deal with all these programs. A lot of them were filled with discriminatory acts.
Relief to millions of Americans through a collection of federal programs and projects called the New Deal. One part of that New Deal was the National Housing Act of 1934, which introduced ideas like the 30-year mortgage and low fixed interest rates.
Holy crap. Are you guys seeing what I'm seeing? A brand new model home, $4,800. $960 cash down and $27.62 a month mortgage payment. I guess that's back in the day where you could order a brand new home to be built out of the Sears catalog too.
So now you have all these lower income people who can afford homes, but how do you make sure they don't default on their new mortgages? Enter the Homeowners Loan Corporation. The HOLC created residential security maps, and these maps, they're where the term redlining comes from. Green meant best area.
Oh, let's back this up a sec. You know what? I think that area with the block busting and the picture and them showing that they paid that girl to push the stroller down the street while they're knocking on doors, I think it came from this documentary. Look, this one's showing Baltimore area too.
Green meant best area, best people, aka businessmen. Blue meant good people like white-collar families. Yellow meant a declining area with working class families. And red meant detrimental influences, hazardous, like foreign-born people, low-class whites, and most significantly, Negroes. Again and again on these HOLC maps, one of the most consistent criteria for redline neighborhoods is the presence of Black and brown people. Let's be clear, studies show that people who lived in redlined areas were not necessarily more likely to default on their mortgages, but redlining made it difficult, if not impossible, to buy or refinance.
All right, so that's where the term redlining comes from. Okay, so now let's talk about disparate impact or disparate treatment. This is a lot more lingo that's been going around again. I mean, it's been around for a long time, but I guess it could be twisted to paint your narrative by getting you to nod your head up and down because you agree with one statement, and then they move on to another statement that kind of stretches stretches it a little bit. Disparate impact or disparate treatment is sometimes referenced as disparate treatment or adverse impact. It's a policy or practice that seems to be neutral, but in fact may disproportionately impact certain groups of people. This results in, okay, so that's only when you're analyzing people not as an individual, but as a group, okay, based on their race, for example. So this results in discriminatory practices, resulting in unequal treatment and hindering of equal access. For example, a lender or property management company may require full-time employment. On the surface, this requirement seems fair enough. However, it discriminates against someone who's receiving public assistance or disability payments. The Department of Housing and Urban Development, HUD, which enforces the Federal Fair Housing Act of 1968. Let's stop right there for a second. Yeah, HUD enforces the Federal Fair Housing laws. And what's your point? They're about to get into, in this book here, they're about to get into something. A lot of laws have been passed in the recent few years pertaining to discrimination, because you've been seeing a lot of these groups going about, they're changing a lot of laws and they're creating a lot of new laws, and they're trying to basically be a bunch of race hustlers, that are trying to push their agendas based on and claim that if you're not for the laws that they want to pass, well, you're being racist. Now, I think the laws and rules that they're trying to pass are based on false information and a racist agenda to begin with. For instance, a lot of these studies or a lot of these laws that are being passed are based on a study that was done by, well, actually, I don't even want to call it a study. I don't think you can legitimately call it a study. During President Obama's first administration, he appointed somebody within HUD to go to prisons and do a head count of how many people are in prison and then segregate them based on their race. So now he's just doing a head count. How many whites in prison versus how many black people in prison? And basically now he's just strictly based off of race of people that are in prison. They're getting a head count. And because they say, well, there's more people of color in prison than there are white people in prison, the criminal justice system has a disparate impact and is of treating people at a disproportionate basis. Okay, instead of asking the question of, are all of these people in prison actually guilty of the crimes? Instead of asking that, it's just saying, let's do a head count and then let's segregate the people based on their races. Okay, right off the bat, what are you trying to get at? What's the point of this? Well, they're trying to build an agenda that basically says that if there's more people of color in prison versus the white people in prison, then the criminal justice system is inherently racist based on that factor alone. Okay. Now, that's nonsense. I mean, if you want to make an argument that maybe cops are pulling over people of color more than they are white people, that's a different argument altogether. Okay. But that's not the argument they're making. They're just doing a head count of people who have been convicted of crimes and have been in prison, and doing a head count of how many people in prison, and then saying, well, because it's not an equal number of people in prison, the criminal justice system is now inherently racist. And now, based off of that report, which isn't a study, it's just a report. There have been now studies that use that report as the basis of their evidence, and then laws created based on that report. And they even reference it. You'll see, even I'm even going to have a video with a NAR attorney that starts explaining how some laws were created in very few states, New Jersey being one of them, based off of this as the evidence. Everybody here, let me ask you a question. I'll show you how this relates. Anybody here own a house? And anybody here own a rental property?
No.
Okay. So even if you don't, if you were, this applies to everyone.
I do.
Everybody can imagine owning their own rental property, okay? So let's just imagine everybody here owns a 4-family house. You live in one of the units with your children and your family. Okay, so you got your whole family living in one of the units and you're renting out the other 3 units. Okay, everybody on board with me here so far? So would you want to do background checks on any potential tenants that you rent to in your house? I mean, criminal background checks as well as your financial background checks to make sure they have the ability to pay and all that. But wouldn't you also want to make sure that do a criminal background check on anybody that moves in your property? I'm talking to everybody here. We have a diverse group of people in this classroom right now. So I'm talking to everybody on the same basis. Would you want to do background checks, criminal background checks even, on the potential renters? Or do you just not care who you rent to?
I would, but I feel like sometimes with renters who do background checks and stuff, they automatically disqualify the individual, no matter what the criminal record may be.
Well, that's a separate issue altogether. That's discrimination straight outright. Okay, that's a different issue altogether. But let me ask you a question: would you want to do a criminal background check? I'm talking about you. You as a person. Would you want to do a criminal background check on any person that's going to move into a house that you're living in there with your kids?
I would. You
would?
Yes.
You're racist.
I'm racist?
You're racist.
Why do you say?
Because I'm just proving a point how ridiculous this is.
But wait, hold on. Hold on.
Okay.
I would do a criminal background check, but I wouldn't discredit them from wanting to live in a unit that I'm renting, depending on what pops up in the background check. Just for the safety, like I don't have children.
Okay, hold on a second. I didn't even get into any of that. I just asked you if you wanted to do a criminal background check.
Let me explain. You just automatic. You're racist.
Well, you know why? You know why? It's not me that's saying that. It's our New Jersey laws that do.
Really?
Our laws were changed recently in New Jersey. We have something called the Fair Chance in Housing Act.
I did mention that. Okay, I'll let you continue.
Yeah. So the Fair Chance in Housing Act basically says because of that report that HUD did back in 2016 or 2015, whenever it was, because HUD did this analysis and there was not an equal number of people in prison based on their race, they determined that the criminal justice system is racist. So therefore, if you want to do a background check based on someone's criminal history, then you're relying on racist information, and therefore, by extension, that makes you racist. Is that the dumbest thing you've ever heard in your life?
That is the way you that is. How did they come to that conclusion to their studies? Just doesn't make any sense, though. I don't know.
Listen, you and me, we're on the same wavelength right here. Now, usually, we're both on the same page here. Okay. This stuff does not make sense at all, how they've been passing these laws lately. Now, I don't understand the motivation behind it. I guess it's like in Portland, why are they allowing riots in the street over here and they're, the Antifa to go running wild, some of the stuff just doesn't make sense. You got the residents that live there that are like, we need help here. We need the cops to do their jobs, you know? Well, over here, it's the same kind of a thing. It's like, what are the politicians thinking? Why are they passing these laws? They don't even make sense to you and me. So why are they doing it? That I can't explain. But let's continue with this lesson. And I'm going to show you, this isn't just me or my interpretation of it. I'm going to show you the actual disclosures and laws that have been written so you can see for yourself. It's not just me trying to twist something to sound like this, that like it's insane. You'll see what I mean. Let's pay attention to the wording even here in the book. It says, the Department of Housing and Urban Development, HUD, which enforces the Federal Fair Housing Act of 1968. That's true. HUD enforces fair housing laws. What's your point? Well, they published a guidance explaining that the use of criminal history to exclude people from housing may violate their prohibitions in certain circumstances. Okay. Housing providers may not use criminal history as a pretext for intentionally discriminating based on race or national origin. I 100,000% agree with that. For instance, applying a criminal record background check on a person of different classes in a different way. Okay, so basically what they're saying is you're doing a criminal background check on a black person, but not on a white person. Yeah, that's racist. But what about if you do criminal background checks on every potential tenant to look into their background, right? Well, they didn't address that. They're just right at this point. They just want you nodding your head. Yeah, I agree. That's racist, which it is. But then they get into something else here. For example, a management company with an intent of keeping all tenants safe might reject an applicant's application based on their criminal history. This ignores groups who are incarcerated at higher rates than the general population. Oh, wait. Whoa. Stop right here. So we're going back to that head count of the number of people in prison, segregate them based on their color, and seeing that if there's more people of this color in prison versus this color in prison, okay, so that's what they're saying right here. This ignores groups that are incarcerated at higher rates than the general population. Who cares about the overall totals and general population? I want to know the individual that I'm renting to, if they're actually a criminal or not, and what crime they committed. And I should be able to determine if I want to rent to them or not based on that criteria. But they're kind of obfuscating the whole thing with this argument that a management company with the intent of keeping all tenants safe might reject an applicant based on their criminal history. But that ignores groups who are incarcerated at higher rates than the general population. We're not talking about groups. We're talking about individual tenants. We're not talking about making excuses for them. This may not result in safer environment. Well, not if you're basing it just off of people by their color of their skin. No, you're doing it based off of their criminal history. Who cares what the overall population in prison is? We're talking about the one person that you're trying to rent to. Yet another example is a zero tolerance for violence, without recognizing that perhaps up to 25% of women have experienced domestic assault. Okay, listen, children, we are not in elementary school here. We're not going to put everybody in the corner because they got into a fight, okay? If what they're trying to explain here is that you're going to be discriminating against a woman who is a victim of domestic assault because you have a zero tolerance. That's not the way zero tolerance works when it comes to rentals. So this policy could negatively impact them. But that's the picture that they're trying to paint here. So, New Jersey's Fair Chance in Housing Act, the FCHA. Beginning January 1st, 2022, New Jersey Fair Chance in Housing Act prohibits landlords from generally asking about criminal history on a housing application. In most cases, landlords are prohibited from running a criminal background check on an applicant until you first agree to rent to them. And then you notify them that it's a conditional offer based on a background check that we still need to run. But you cannot tell people in advance that you're doing a criminal background check. You first have to agree to rent to them, and then you need to prove your reasoning about why you don't want to rent to them because of their criminal background check, and give them the opportunity to point out what in their criminal history is not right. Why do they want you to do this? Well, because they want you to open yourself up as a landlord to lawsuits if you're not wanting to rent to somebody because of their criminal history. Look, this is my 2 cents to it, how I explain it. This is my advice. You could ignore it all you like. This is just my 2 cents on this situation. It's my advice to you as real estate professionals. The best we could do with contradictory guidance like this is to be a good person, to treat everyone equally fair and just. Hopefully, you're not going to get sued in the process. Politicians, in the name of fair housing and something called equity, are justifying a systematic racism claim by absolving individuals of their personal responsibility and accountability for their own actions, instead judging individuals based on the racial groups that they fall into as a reason to excuse them. Law-abiding citizens, doesn't matter what race you are, wanting to safeguard their family, property, and tenants, have a responsibility to do so, and could be found guilty of discriminating for denying renters who have a criminal history. Sounds crazy, but that's now the law here in New Jersey. Here, I'm going to let this NAR attorney explain it. And I don't know how she even gets away with doing it with a straight face, because I'm going to pause it at certain points and point out something to you, okay? Let's watch this.
Welcome to Window to the Law. I am Mame Nyamiche, staff attorney at the National Association of Realtors. In this episode, I will discuss why it is important to give your criminal background screening practices a second look in order to avoid a fair housing violation. In fact, several housing providers have found themselves faced with lawsuits alleging the misuse of criminal history in violation of fair housing laws. In New York, a housing provider recently settled a case for over $1 million, where the plaintiff alleged that the housing provider maintained an overly broad ban on renting to people with criminal records. Okay, so what did she just say? Somebody got sued and they settled so that the problem went away. They gave them they settled with $1 million when they were accused of doing an overly broad criminal background search, whatever that means, In Florida, as many as 48 Florida housing providers were also sued for the alleged improper criminal background screening of prospective tenants. Okay, it doesn't say they were found guilty of anything. It just says they were sued. Okay, your point? The use of criminal histories to make housing decisions has long been on the fair housing advocates' radars. In 2016, HUD issued guidance urging housing providers to exercise caution when implementing criminal history policies and practices to make housing decisions. In the guidance, HUD reported that African Americans and Hispanics are arrested, convicted, and incarcerated at disproportionate rates compared to the general population, resulting in criminal history-based barriers to housing and creating a disproportionate impact on minorities. Okay, let's stop there for a second. Let's use that information and that data the way they're explaining it there. They did a head count in prison, and there's more people of color in prison versus the white people in prison. So therefore, there's a disproportionate impact to the people of color because there's more people in prison convicted of crimes. Okay, well, how about this? How about I make another argument? Let's compare the number of white people in prison versus the number of Asian people in prison. There's way more white people in prison than there are Asian people in prison. Does that make white people now a disproportionately impacted class? You see, the argument doesn't play. It only plays when you try to paint a certain picture. And I don't know why they're doing it. Let's just talk about whether they're actually a criminal or not. Let's forget about talking about people as groups. Let's talk about them as individuals and hold them accountable for their own actions. That's the way I look at it. If you're truly not racist, all you're going to do is look at people and hold them accountable for their individual actions. Minorities. While persons with criminal records are not a protected class under the Fair Housing Act, race, color, and national origin are.
Yes.
And the improper use of criminal history to make housing decisions may have a disparate impact on those protected classes. Under a disparate impact analysis, a housing provider may be held liable for discriminating against a protected class absent any evidence of intent or motivation to discriminate.
Say what? You guys heard the same thing I did, didn't you? I'm going to rewind it so you could hear it again.
Against a protected
Let me back it up a little bit more.
housing provider may be held liable for discriminating against a protected class absent any evidence of intent or motivation to discriminate.
You could be found guilty of discrimination absent of any evidence or intent to discriminate.
Meaning, liability may arise when a facially neutral policy or practice has or predictably would result in a disproportionately negative impact on a protected class under the Fair Housing Act.
Now, how would that happen? Well, because we did a head count in prison based on that 2016 report from HUD that says that there's more people of color in prison versus white people in prison. So therefore, if you're going to do a criminal background check on people, the criminal justice system was racist inherently. So therefore, if you're relying on criminal background checks, you're racist by extension. I know it's ridiculous, but let's continue.
Some states and localities, such as Illinois, New Jersey, and the District of Columbia, have even enacted laws restricting a housing provider's use of criminal records. Consider these best practices when using criminal history to make housing decisions. Have a written criminal history policy. Apply criminal record policies consistently. Do not ask or consider arrests without convictions.
Of course.
Avoid blanket bans on applicants with a criminal conviction. Be sure to exclude only those with convictions that present a demonstrable risk to resident safety or property.
And how do you do that? You do it based on their criminal history. I mean, I can't for sure 1,000% say that somebody's going to or not going to commit a crime again. But the way that we do is we look at their criminal history. That's like, how do you determine whether you're going to give somebody a loan, if they're more likely to repay you or not? Well, you do a credit check on them. So what, should we not do credit checks on people now? Because it would disproportionately impact those who have a history of not paying their bills?
Document housing decisions. And become familiar with local and state laws that apply to a housing provider's use of criminal histories. For more information on use of criminal...
Okay, so we didn't get a whole lot out of that, other than you can be found guilty of discrimination simply by doing a background check on somebody. All right, before we get more into that Fair Chance and Housing Act, the nonsense law that was created there that basically makes ex-cons a protected class, and I'll show you how. I'm going to show you the law specifically, how it affects us as whether you're a landlord or you're a real estate agent. But before I do that, here's an older video that I've been showing for years now, and I like showing this video because it shows a real estate agent from start to the resolution. It shows a real estate agent that is actively engaging in discriminatory acts in an undercover sting by this news guy. So basically, this young white reporter here on the news, he was getting married to his fiance, which was a black woman. Now, the person where he went and he looked at this condo, he only met her. He went there and checked out the place. And he figured that she seems like she may be engaging in discriminatory activities. So being a news guy that he is, he figured that he's going to do an undercover little sting here operation. So he got some of his friends, his white friends, his black friends, his friends from different ethnicities, backgrounds, sent them in as couples, as singles, just to see what her reactions would be. And he caught her. Like, I'm going to show you. This is what it looks like. Now, this happened. I think this is in, I don't know. I think it's in one of the Carolinas.
High rise in Colombia. No African Americans living there. Is there a reason? Good evening, and thanks for being with us on.
Just to make sure that this plays right, let me minimize my video and the streaming here so it streams through a lot easier. Okay, let me get it going.
MJR.
And I'm Darcy Strickland. The reason could lie with one real estate agent. A News 19 investigation uncovered what appears to be active discrimination inside a prominent Columbia high-rise.
News 19's Johnny Chappell has been working on this story for months now, and he joins us with the details.
A lot of us here have put a lot of work into this story, and we hope that we can bring some possible good out of it, JR and Darcy. Who has the right to tell you where you can live? In January, I started looking to buy a new home. The very first place I visited, a realtor told me that for 25 years, the building had remained exclusively white. Her comment sparked our investigation, and our investigation has the federal government looking to take action. Looking up from anywhere between 5 Points and downtown, it's hard to miss. 1829 Senate Street, a 30-year-old high-rise, 19 stories of high-end housing. In all, 96 luxury condos. The Heritage, all white on the outside, and there's a woman who may be trying to keep it all white on the inside.
We do not have a mixed neighborhood here.
Ann Bryant is a longtime Heritage resident. She's also a realtor, and she shows just about every property that comes up for sale in the building. After my experience, we sent a team to investigate.
You get 7, that's good. I'm going to take you to see my son's unit first. Okay.
A News 19 employee and her sister told Bryant they wanted to see what was available. Bryant showed them 2 occupied condos before going inside a condo for sale on the 12th floor. At the time, the residence was not on the market. Bryant said she thought it would list for around $170,000.
When I have a listing anymore, I mean, I may not even put it in the computer because it's just, they go like that.
Didn't she just admit to violating the law right there? When you get a listing, what are you supposed to do right away?
Insert it in the system.
Yep, within 48 hours. She's saying that she doesn't even do that.
And she said that all prospective clients and their realtors go through her.
I meet people to show in the building. I mean, if it's another agent showing, I meet them.
Bryant went on to indicate that race determines whether she allows a person to see or inquire about purchasing property.
And I'm very careful when I make this statement. We do not have a mixed neighborhood here. And I think that is because we try to be careful and we try to, not that nobody dislikes them. I work with them all the time. It's just that they tend to, I'm talking too much.
I think
they make a neighborhood go down because they don't take care of their yards and they just.
She makes those differences appear black and white.
We do have some Orientals in one of the penthouses. Been here for years, nice as they can be.
There is no reason whatsoever that she should be talking about anybody's race. None.
Those statements marked the 3rd time we had heard Bryant referring to possible discrimination. She said it to me during my visit and to another News 19 employee during a previous trip. We showed the tape to Dudley Gregory, who's with the U.S. Department of Housing and Urban Development.
That conversation is enough to give me pause and that I would want to look further.
Gregory said Bryant's behavior very likely violates a federal law. Under the Fair Housing Act, a realtor cannot discriminate in 7 protected areas, including race.
The issue is how many people have been to that place that are minorities that have been denied to even come through the door.
Local realtor Shelby King says those licensed in her field must complete class time every 2 years to keep up to date on the Fair Housing Act.
We are reminded about fair housing constantly.
King cites standard clauses in buyers and sellers agreements that deal with the law. She says there are certain things a realtor cannot discuss when showing a property, and that sometimes she's had to steer clear of a client's questions.
And they will usually preface the statement with, I'm not prejudiced, but what's the mix of the neighborhood? And I cannot address that.
So why would Ann Bryant, who's required by her profession to adhere to a federal law, risk losing her license? She agreed to meet us at the Heritage for an interview. You said you show most of the properties here. To the best of your knowledge, have you ever discriminated based on a person's race as to whether or not they can live here?
Anybody can live at the Heritage. We have no discrimination of any kind in the building.
She denied ever talking about race with potential buyers, even after I told her about our investigation. We've had several people come to us and say that you say that this is not a mixed community, that it's only white people are allowed to live here.
No, I've never made that statement to anyone. I would certainly lose my license if I did a thing like that. We do not have a mixed neighborhood here, but I've never made a statement like that.
So here's what's happened as a result of our investigation. Today, Ann Bryant submitted this letter to her employer. She's retiring from real estate effective immediately. To remind her agents and their agents of the importance of this issue, her former employer is requiring each agent to sign a second ethics policy. Also, I've spoken with the president of the Heritage Homeowners Association. His comments: we don't discriminate in any way at all on the issue of why Bryant has been on hand almost every time a prospective buyer looks at a condo for sale in the building. The president said, quote, she is not authorized by the board to show property. After viewing our tape, HUD opened its own investigation. HUD officials have told us their attorneys will be able to make a decision based on the possible violation of federal law very soon. And of course, J.R. and Darcy will keep you posted.
Well, Johnny, has this realtor had any past incidents?
We found out today, yes, she has. In 1997, a couple filed a claim against Bryant's former employer, naming her and her realtor as accusing her of steering. That's a practice referred to right here in the Fair Housing Act. Protected class, what type of housing or location would or not be appropriate for them, steering them in that direction. Her employer settled that claim, and Bryant had to pay a fine for that offense. So certainly a lot coming out of this story still to come, and we're going to continue to follow it in the next couple of days.
All right, Johnny, thank you.
Sure.
Well, we also contacted the State Realtors Association after our investigation of the Heritage, and this is how they responded to what we uncovered. Realtors adhere to a high standard of integrity and a code of ethics that requires equal access to fair and affordable housing for all, regardless of race, color, religion, sex, handicap, or national origin.
He missed familial status. I guess he couldn't pronounce it.
They go on to say, as realtors, we deplore and will actively pursue action against any member whose actions run contrary to the federal or state fair housing laws or the Realtor Code of Ethics.
Well, we would like to get your feedback on our investigation of the Heritage.
All right, so let me fast forward because we did get a resolution to it and find out what happened. Here we go. In 2005, HUD launched an investigation and they reached a settlement with Century 21 Bob Capes Realtors, that's her broker. Bryant had to give up her real estate license and then she died shortly after. So what happened? Jared Glover, a black public relations specialist for the city of South Carolina, was Chappell's roommate. Chappell is that reporter. You know, remember I told you he did this sting operation there and he got his friends. He got his old college roommate, which was this guy, Jared Glover, who's also now a public relations specialist, and he's a black guy. And he sent him in there to do an undercover thing to see how she would treat him as well. And he was affected by her comments, so he sued as well. And then her brokerage awarded him a $90,000 settlement. So this lady's already dead. And her broker's still paying for her actions. Remember, I told you guys, it's a big responsibility to be a broker. You could be held liable for things that your agents do. Look, this agent, she's not even around anymore. She died. And the broker's still having to shell out $90,000 because of her discriminatory acts. Why? Because the broker's supposed to provide guidance and direction, and they can be held liable, right? What do we call that when the broker can be held liable for their agent's acts? If they had
the knowledge.
Guilty knowledge, correct. And it's not enough for them just to say, well, I didn't know. Because she actually had a history of this kind of behavior. The broker should have been keeping an eye on her if he was going to allow her to work for him. He should have been keeping closer eye on her, especially since she has a history of this kind of behavior, to make sure that she's not engaging in it again, you know? Okay, so what did you think about that? Where you saw the story from the beginning to the end, you know, how they reported it, the investigation, and then what the final conclusion was. It was a good example of how you could see how somebody's doing something wrong, and then they get caught, they get blamed, they get investigated, then there's a settlement. So that's why I like showing that. It gives you the whole story there. Okay, now, enforcement of anti-discriminatory laws. We know that HUD would enforce the federal anti-discriminatory laws, the Civil Rights Act of 1866, as well as the Federal Fair Housing Act of 1968. So you have 1 year to file a complaint and have charges heard in front of an administrative judge within HUD itself, or 2 years if you want to make a federal case out of it and have it heard in federal courts, and in which case there is no monetary limits on awards and settlements. Now, an injunction, this is on page 73 somewhere. I'm going to have you highlight this in a moment. I'll show you a screenshot of it. But for some reason on state exam, they always want you to know what the word injunction means. An injunction is when a judge orders somebody to take action or to refrain from taking action in some way. Like a judge can order a landlord who previously denied renting to somebody to rent to them. A judge is ordering somebody to do something or to refrain from doing something. Okay, that's what an injunction is. Okay, now we're going to learn about New Jersey law against discrimination, the LAD for short. All real estate is covered by the LAD, residential and commercial. So what kind of property does the LAD, the New Jersey law against discrimination, cover? All real estate, not personal property, just real estate, whether it's residential or commercial. So we have the Civil Rights Act of 1866. What kind of property does that cover? All property, real and personal. The Fair Housing Act of 1968 covers only residential real estate. And the LAD, the New Jersey law against discrimination, covers all real estate. Complaints are made to and enforced by the State Attorney General's office. That's the highest law enforcement officer in our state. That's what that position of the Attorney General is. And if you violate the New Jersey law against discrimination, you have 6 months to file the complaint, or 180 days, 6 months to file the complaint. And those who interfere with an investigation are subject to a $500 fine and a year in prison. Attorney General's memorandum. Attorney General is the highest law enforcement officer in the state.
So when we were doing enforcement, it says 1 year, but now it's what? How do I know the difference?
Okay, hold on a second. Under the federal law, if you want to have the course, if you want to file a complaint and have the court case heard in front of an administrative judge within HUD itself, HUD has their own investigators. Like that guy in the last example I showed you, he brought the case, the videos that he had, and he showed it to the HUD investigator who opened up the case to investigate her. And then that case could be brought directly to a judge within HUD itself, that all they do is listen to discriminatory cases. Okay, you have 1 year to file a complaint and have it heard in front of an administrative judge within HUD. But if you want to have it go to federal court, because where there is no monetary limits on fines, awards, or penalties, or if you go past 1 year and the deadline to have it heard within an administrative judge within HUD, you could take it to federal court and then have 2 years to file a complaint. And in that case, there's no monetary limits on awards or settlements.
And then New Jersey is.
And then New Jersey, specifically New Jersey's law against discrimination, you have 6 months, 180 days to file the complaint with the state attorney general's office, who does the investigations for violations of the New Jersey laws against discrimination.
Thank you.
You're welcome. Okay, so the attorney general is that highest law enforcement officer in the land. Every state has their own attorney general. The country has an attorney general. Okay, so the state attorney general's office, that's the highest law enforcement office in the land. A memorandum is a fancy word for a notice. So an attorney general's memorandum is a notice coming from the highest law enforcement officer in the state, and it's about the New Jersey laws against discrimination. You do not give the laws to people. You give them the attorney general's memorandum that talks about the laws. So the attorney general's memorandum is a disclosure about the New Jersey law against discrimination, as well as some of the federal laws. And it must be given to property owners at the time we get a listing, whether it's residential or commercial property. The property owner, anytime we're getting a listing for a property for sale or rent, doesn't matter if it's residential or commercial, they need to be provided with a copy of the Attorney General's memorandum, which talks about the laws against discrimination, that's the state laws, as well as the federal laws. We got to give that to them at the time of listing. So what do we give to property owners at the time of listing? We give them the Attorney General's memorandum. You don't give them the LAD. The LAD is the law. The Attorney General's memorandum talks about the LAD, right? You give them the document that talks about the LAD. You don't give them the law. You give them the document that talks about the law, okay? I just want to clarify this because I remember when I was in your position studying for these exams and I took my notes. I know I got questions on exams. I know I was getting them wrong. I was confused with this. And then I was reviewing my notes and I was like, what the hell's the difference between the Attorney General's memorandum and the LAD? They look like they do the same thing the way I wrote my notes. Okay, well, the LAD is the law. You don't give people the law. Instead, you give them the document that talks about the law. That document is called the Attorney General's memorandum, just to clarify it for you. Okay. Now, licensees, that's us, we must refuse listings when a property owner indicates that they intend to discriminate. So if somebody tells you, even if they're just joking around with you, after you give them this document, the Attorney General's memorandum, if they tell you that they intend to discriminate, you turn down the listing. There's even going to be an exam question on that, I'm sure. What do you do when somebody indicates that they have an intent to discriminate? You refuse to take the listing. Okay. Now, 2021, they updated the Attorney General's memorandum, which also included, I think, 2 new protected classes in the state of New Jersey. New Jersey has more protected classes than anybody. As a matter of fact, when we read the actual Attorney General's memorandum, you're going to see that if you think somebody's a protected class, they just became a protected class. And we also have that Fair Chance in Housing Act that basically essentially makes ex-cons a protected class. Now, I know the attorneys here, and even the document itself says this does not make criminals a protected class, but then they go on to explain how it makes criminals a protected class. So it's kind of nonsensical for them to even say that. Because look, if you do a criminal background check on them, you know, you're basically discriminating against the person because of their criminal history. But they tell you, no, it's not because of their criminal history. It's because you're racist, because the criminal justice system is racist. And if you're doing a criminal background check on them, that by extension, therefore makes you racist. I know. Follow the bouncing ball, get the questions right on exam. Don't argue it here. Okay. Okay. So under the New Jersey law, what are the penalties for violating the LAD? It's up to $10,000 for a first offense, up to $25,000 for a second offense, and up to $50,000 for further violations. So 10, 25, 50, 10, 25, 50. Remember that. You'll need to know it for exam. Now, what are the fines? Are there any fines or penalties for violating the Civil Rights Act of 1968? Yes. However, the numbers are so obscure. I don't know how you'd memorize them. So they do not got questions about it on the state exam. I'll show you when we do some highlighting on the next slides. You do not need to memorize what the fines are for the violating the federal laws, because those numbers are just whacked out. I don't know how they come up with these numbers. They pull them out of thin air. But for New Jersey's violation of the New Jersey law against discrimination, you do need to know the fines: 10,000, 25,000, 50,000, up to. Okay. So I got in here everything you need to know about the LAD for exams to study. You may want to snap a picture of this because in the book it is all over, and it doesn't even explain it as clear. You'll see what I mean in a moment.
I have a question.
Shoot.
I was trying to click on one of the links in the tab as far as like the stuff that you have stored that we can study on our own time. And for some reason, it just kept giving me like an error message.
Yeah.
I'm gonna write it in the chat so I don't throw you off course.
Okay.
If you could just take a look at it sometime this evening.
Sure. What link was it? To the shared Google Drive or to one of
It was one of the Google Drives.
Oh, wait, hold on a second. I got a notice. Oh, wait, no, that's not it.
I don't remember which one it was exactly, but it was definitely one of the Google Drives.
I got a notice too, but it was because the document was large, and it just tells you, at least on mine, it tells you Google doesn't scan it. You can still download it. There's a little link on the bottom, but it's too large for Google to scan it. So you're
if you're downloading some of the slideshows, like chapter 3 slideshows, big because it's got those videos in it. Do not try to open it and run it in your browser. Instead, you could even right click it and just download it, or if you got it, I don't know how you do that on an Apple because they don't have a right mouse button. So, but yeah, there's a way for you to download them there. So just download it to your computer and then you could run it from your computer. Is that what the issue was, opening the file?
She confirmed. So so when we're done with class, I'm gonna do it that same way, because these slides are actually like a shortcut than what's in like the textbook.
Yeah.
That's how I did it, because it was giving me the same issue, but it's that it just tells you, like, a pop-up window comes up saying you can't download because it's too big, and then at the bottom says continue to download, but you run the risk that Google didn't scan it, but they're good.
Okay, thank you so much.
You're welcome.
Thank you with that. Okay, so let's go back there to the slideshow. You guys should be seeing it by now. Yeah. All right, so everybody got a screenshot of this? Okay. So now let's do the highlights in the book for all this stuff. But before you do, hold on, let me show you here. These are the fines for violating the federal anti-discriminatory laws. The Federal Fair Housing Act of 1968. Look, for a first offense, the fine ranges from $24,793 to a second violation of $61,984 to further violations of 123,315. I don't know where they get these numbers, how they would make them up. I don't. You're not going to need to study them. You're not going to get those on exams. I don't know how you would remember them. But the New Jersey one, it's easy to remember. 10, 25, 50. 10, 25, 50, right? So let's just do these highlights, though. And then you got the injunction. What an injunction is. It's when a judge orders somebody to take action or to refrain from taking action. It's like if a landlord refused to rent to a tenant because they were discriminating, a judge can order them to rent to that tenant. Or if the tenant ended up going and getting having to go rent somewhere else because they were denied rent because of discriminatory reasons, and that tenant had to find another place elsewhere that cost more, the judge could order that landlord to pay the difference for as long as they live there. All right, you guys got these highlights, right? All right, in case you didn't know, you can't use threats or acts of violence to get somebody to move or sell. If you do, contact your local FBI or police department and report them. Your local office of the FBI, the Attorney General, or police, and report them. Okay, as you can see here, New Jersey law against discrimination has a lot more protected classes than the federal law, which has 7. Here we have race, color, national origin, ancestry, nationality, creed. Creed is your doctrine of religious beliefs, no matter how wacky they could be. We got those Scientologists and all kinds of other people who believe aliens are coming back. That's what Scientology is based on. Sex, gender, identity or expression, affectional or sexual orientation, marital status, civil union status or domestic partner status, familial status, pregnancy or breastfeeding, actual or perceived mental or physical disabilities. That includes people with AIDS, HIV, COVID-19, you name it. Source of lawful income used for mortgage or rental payments, lawful income for mortgage or rental payments, like Section 8 housing choice vouchers, the state rental assistance programs, TRA, which is temporary rental assistance that comes from Catholic and Jewish charities in New Jersey, as well as liability for services in the armed forces in the United States. That's a new one. How sad is it that people are discriminating against people in our military that choose to serve our country, that they discriminate against them? I guess it's like the return from Vietnam, where you get these hippies that are spitting on soldiers when they return. So they had to actually make them a protected class. It's also illegal to place any advertisements or make any statements or utterances that express directly or indirectly any limitation to offer housing or real estate based on any of those characteristics. Now, technically, under the FCHA, ex-convicts are now referred to as system-involved people. Yes, they're changing the vocabulary. They're censoring the language. They don't want you referring to them as ex-cons because that sounds so bad. So they want you to call them system-involved people. Okay? And they're considered a protected class now in New Jersey, those system-involved folks, whatever system-involved means. Who are the rewriters of the language? That's incredible.
So now, if I have a tenant that's okay, so basically they do the application, right? I offer them the apartment. Then I run the background check, and it comes back they're a sex offender. I can't say, no, you're a sex offender.
It depends.
Like, what's the law after you find out they?
If she owns the place, right?
It's a good question.
Resides there.
Hold on a second. It's a good question, and we're gonna get to it just shortly because we're about to start going into the New Jersey law against discrimination now. So this is basically, we went over the protected classes here, and let me skip that. We'll go over these exemptions, and then I think we're gonna. There we go. Here, we're going to be going over the Attorney General's memorandum. We're actually going to read through it, and I'll show you with the exact process who it is that you can and cannot, or who you can refuse to rent to. And it's going to be clear as mud. I'm serious. The way that they wrote the law, you practically need a law degree to figure out who you can legally deny. And I think that the politicians did this on purpose because they want you to rent. They don't want you to deny renting to ex-convicts, system-involved people, sorry. But the interesting thing is, as we read this document, they carve out exceptions for themselves. Don't politicians always do that? You know, laws for thee, but not for me. You know, that's the way that they do it. And you'll see when we read through it. You know, I don't make this stuff up. It's on their paperwork. I didn't modify their paperwork at all. I'll show you. So here's the next section. The prohibited activities and exemptions to the New Jersey laws against discrimination now. And it's basically the same as with the federal laws, okay? Refusing to sell, rent, lease, assign, or sublease as a means of discrimination. For licensees, refusing to offer property or to negotiate transactions as a means of discrimination, or lying about the availability of a property. Changing the terms of real estate transactions or offering special facilities or services to any person or group as a means of discrimination. Being involved with any expression, verbally, directly or indirectly, or any limitation based on discrimination. This includes statements, advertisements, publications, signs, rent applications, purchase offers, or records of inquiries. Now, the only exceptions to the New Jersey law against discrimination are to rentals. It allows rooms, apartments, or flats in certain types of housing to be restricted to members of one sex. I guess that's like college dormitories, you know. Religious, although the thing is, with the introduction of the term gender, it seems like they're basing a lot of this stuff off of gender now instead of sex. Because sex, there's male and female. Gender, I could be a woman if I want to be a woman. So now I could be in the college dorms with all the girls because, you know, I'm a woman, you know. So how does that actually play? We're not getting into that. I'll tell you right now, we're not getting into that. That gets really wacky. We're just learning the laws. Let's learn the basics before we start getting all crazy and driving ourselves nuts about how we figure out this stuff. Religious-based organizations to discriminate on the basis of religion, and an owner-occupant to discriminate except for race in the rental of a duplex or over-under two-family dwelling. Duplex is two-family house side by side. Over-under is one above the other. Now, note that these exemptions are similar to those available under the Federal Fair Housing Law. New Jersey's law, however, does not contain the federal exemptions for homeowners selling their own homes or when the broker's involved. There's never exceptions for race, whether or not a broker's involved. I put together this little quick at a glance to see what laws cover what kind of property is covered by what law. So we got personal property, residential, or commercial property. So The Civil Rights Act of 1866 covers all property, residential, commercial. It covers all real estate and personal property. The Fair Housing Act, housing, covers residential property only. And the New Jersey LAD, it only covers real estate. It doesn't cover personal property, but it covers all real estate, residential and commercial. See, so I put together this quick little guide at a glance. You could see what's covered by what. Okay, blockbusting and record keeping. So to make sure you're not engaging in blockbusting activities, if you get 3 or more listings on a block or on a street, I think it's a block. If you get 3 or more listings on a block within a single month, you need to keep records about what kind of advertising did you do to get that. Were you doing door knocking, door to door? Well, if that's the case, you need to write down the script that you were talking to people that you managed to convince them to sell their homes. And if it was a mailing piece or other advertisement, you need to keep a copy of that for at least 1 year in case somebody wants to file a complaint and file a suit that you were engaging in illegal blockbusting. Now, New Jersey also has an equal housing poster, just like the federal government. However, failure to display that poster is punishable by a $100 fine or more. You're not automatically guilty of discrimination, like with the equal housing opportunity poster. If you don't post that, you're automatically guilty of discrimination. Here, you're just fined $100 or more for not displaying it. Okay, everybody got these highlights from 76?
Yeah.
This is what New Jersey's equal housing opportunity poster looks like, although they change it a lot, so I'm sure there's a lot of variations to this floating around. So what do they cover here in this poster? 5 things you should know about New Jersey law against discrimination. New Jersey law against discrimination, the LAD, prohibits discrimination based on any of these protected classes. Oh, and here they also throw in gender, sexual orientation, gender identity or expression. Okay, we already read through all that. The anti-discriminatory provisions mean that an employer cannot fire someone, pay someone less money, or refuse. Okay. The LAD also prohibits bias-based harassment, which is basically sexual harassment. I'm going to go over an example of that here in New Jersey. The LAD prohibits retaliation, I guess like a whistleblower type law. And New Jersey Division of Civil Rights enforces the LAD, the DCR. New Jersey Division of Civil Rights, DCR, enforces the LAD and is tasked with preventing and eliminating discrimination, bias-based harassment, anyone who believes. Okay, so I guess you could file a complaint with the DCR. They say the Division of Civil Rights enforces the LAD, but actually HUD is the Attorney General's office is the one that does the investigations on this stuff. So that's interesting that they put in there the DCR. Okay, so enforcement. We already had all this stuff on my slide. This is about New Jersey law against discrimination, what the fines are, who you file the complaints with, even though on this poster it says, you know, that the Division of Civil Rights enforces the LAD. It's actually the Attorney General's office that does that law enforcement activity. And anyone found guilty of violating the Fair Chance in Housing Act, the FCHA, yep, $1,000 fine, up to $5,000 and up to $10,000. So this is fairly new. Are there questions on exams about it? I'm sure that they put one in. So the FCHA fines as well. Okay. So as you guys do those highlights, I'm going to go take a potty break really quick. I'll be right back. Okay. Got to go to the bathroom really quick. Doing a pee-pee dance over here. So I'll be right back with you. Okay, so everybody's got these highlights now. Let's move on. And this was also on that one slide that I showed you with my slide with the Attorney General's memorandum. Has to be given to the homeowner at the time the property is listed. And salespeople and brokers must refuse listings from owners who indicate that they intend to violate the LAD. Okay. That's on page 78 there. Oops. All right, let's get into the actual Attorney General's memorandum here. There's this newer version. Actually, I think it's in this version book too. Yes, it is. So this version book does have this latest version. Wait, does it? December. Yep. Okay, so this book has the latest version here. Let me click on it. I'll share you the link in the shared Google Drive directly to it. Whoopsie. That is it right there. That's the Attorney General's memorandum, the AG memorandum with the FCHA, the Fair Chance in Housing Act. There's the link that was up here. So as you can see, it's got the Great Seal of the state of New Jersey up there, coming from the Office of the Attorney General, Department of Law and Public Safety, Division of Civil Rights. It looks like an email, right, to property owners from the Attorney General, and the subject is housing discrimination laws. Now, I like this version of the Attorney General's memorandum, or at least the last couple versions that have been out for the last few years already. When I got started in real estate, and for several years beyond that, there was never examples of the law. I would always have to tell people that they need, because this document just told them that they had to follow the law, but it never gave any examples of common issues that pop up. This version of the LAD, the Attorney General's memorandum, talks about examples of problems and issues that do commonly come up. So it's not us trying to tell people how to interpret the law, but it's actually spelled out on the document already for them, some of the common ones. And so let's go over this. New Jersey Real Estate Commission requires every licensed broker and salesperson whom you list your property to give you a copy of this notice. And the purpose is to help you comply with the New Jersey Law Against Discrimination, the LAD, and the Fair Chance in Housing Act, which came into effect January 1st, 2022. So under the LAD, it's illegal to discriminate against a prospective or current buyer or tenant because of their actual or perceived race, religion, national origin, nationality, ancestry, pregnancy or breastfeeding, sex, gender identity or expression, sexual orientation, familial status, defined as having care or custody of a child under the age of 18 or being pregnant, disability, liability for services in the armed forces of the United States, marital status, civil union status, or domestic partnership status. It's also illegal to discriminate against a prospective or current buyer or tenant because of any source of lawful income to be used for rental or mortgage payments. And it's illegal to make, print, or publish any statement, including print advertisements and online postings, expressing any preference, limitation, or discrimination based on any of these protected classes. So the LAD applies to a wide range of activities, such as advertising, selling, renting, leasing, subleasing, assigning, and showing property, including open land. And here's some issues that commonly come up when enforcing the LAD. Thank God it's in there for you. You know, I had to deal with some people, which I'll share some examples as we go through this, that I came across. So the prohibition of discrimination based on the source of lawful income means that a landlord can't discriminate or reject a prospective tenant because they intend to pay with subsidies or vouchers provided by federal, state, and local rental assistance programs. Basically, their source of legal, lawful income, which includes Section 8 housing choice vouchers, which Section 8, for those that don't know, is a rental subsidy. But they also do provide subsidies for people to buy houses too that may be low income if it will save the state money to purchase them a house instead of just paying rent for them forever. Because some people, Section 8 is a subsidy. It's meant to be a temporary subsidy, but for some people, they end up being on it for a lifetime because maybe they have a disability or they're just low income or whatever the case is. But you get some younger folks too that they get on it, and this ends up being like instead of just to be a temporary subsidy until you get by, get on your feet, or get a better job that pays more. They get hooked on, let's call it the government cheese, okay? And they want to collect these funds, and they work under the table or get money from other sources. That this is not to impugn everybody that's collecting Section 8, because it's definitely not everybody on Section 8. You get plenty of hardworking people that are collecting Section 8 housing vouchers. They're just lower income, and they need that little subsidy to help get by and live comfortably. Okay, but it gets a bad rap because the bad apples are rotten to the core, and they kind of overshadow the good people that are collecting it. Now, COVID-19 emergency rental assistance program. And state rental assistance programs, temporary rental assistance, as well as money from eviction prevention programs, unemployment benefits, child support, alimony, and supplemental security income. A housing provider cannot advertise a property in any way that discriminates based on source of lawful income, including posting advertisements that state directly or indirectly a refusal to accept or express any limitation on vouchers or subsidies. For example, you can't advertise and say no Section 8 or TRA not accepted, or this property is not approved for Section 8. See, some landlords try to get away with that. They say, well, in order for you to have Section 8 pay for it, the property needs to be approved by Section 8. Our property is not approved by Section 8. Listen, their standards aren't that high. Your property will get approved by Section 8. If you got a tenant that's interested in it, they're going to report it to their housing officer that they want to rent this property. As long as they got permission to move, their housing officer will send out an inspector. They'll go out, they'll check it, it'll get approved, and now you're on the Section 8 housing approved list. Okay, it's not their standards ain't that high, so they violate the LAD. So if you say these things in your ads. So in addition, housing providers must calculate any minimum income requirement, financial standard, or income standard based solely on the portion of the rent that's to be paid by the tenant rather than the entire rental amount, which is being subsidized. Now, the LAD prohibits bias-based harassment in housing. It's basically sexual harassment. If a tenant is being subjected to bias-based harassment that creates a hostile environment, and if the housing provider knew or should have known about it, the housing provider must take reasonable steps to stop it. That includes a harassment by other tenants. Wait, how is a landlord supposed to prevent other tenants from sexually harassing you? In the past, listen, I used to be a superintendent of an apartment building. I'm not your nanny. I'm not the teacher that's taking care of, all the little children here. You got problems with your neighbors, you call the cops, right? Who am I as a superintendent? I'm not going to be stepping in the middle of fights and things and ridiculous arguments, although I have. We shouldn't have to. So that includes harassment by other tenants and by the housing provider's agents and employees. A quid pro quo sexual harassment, for example, is where a building superintendent demands sex or sexual favors as a condition for making necessary repairs or to help you apply for your continued receiving of benefits. And I have an example where this actually happened not too long ago, well, 2021 or 2020. Okay, this was in Elizabeth. So you got this one guy that owns all these properties and then some. As a matter of fact, I think I even dealt with him one time. Joseph Santani. The guy's got a lot of money. I don't know why he needs to sexually harass his tenants. So the federal authorities have filed a lawsuit accusing a city landlord who rented to low-income residents of demanding sex from residents on multiple occasions in exchange for assistance. The sexual harassment complaint filed by the Department of Justice in the U.S. District Court of Newark named Joseph Santani, who authorities said owns numerous properties in and around the city of Elizabeth, ranging in size from 4 to over 100 units. Santani receives about $102,000 each and every month in housing choice voucher programs or Section 8 rent subsidies. That's not all the money that he's getting. That's just the money that he's getting from these subsidies. The lawsuit alleges that since at least 2005 until last year, Santani engaged in a severe or pervasive sexual harassment that included demanding oral sex in exchange for helping residents stay in their housing or receive rental assistance. Authorities also allege that he threatened to evict tenants who rejected his advances and also demanded sexual favors from prospective tenants. Can you imagine? You're not even renting there. You're just going to check out a place you may possibly move into, and this guy's like sexually harassing you already? Yeah. What a loser. I mean, this guy got this much money. Your play is that bad you can't get yourself a woman? Come on, man. Jeez, I sound like Joe Biden. Come on, man. That's craziness. But obviously, here's an example of where it does happen. Actually, I know growing up a couple of years back, I knew a girl that lived in this apartment building. And I remember I was picking her up one night to go out. We were going out to a show. And I picked her up and, I'm honking the horn. I'm like, what the hell's taking her so long? She's like, sorry, the landlord got me in the hallway. He wouldn't let me go. He's such a freaking perv. Now we know. Okay, how about this one? Now, while it's disgusting and understandable to be uncomfortable living there, knowing things like this are happening, if a landlord's employee enters your apartment and then masturbates in your fiance's panties, does that constitute a crime or sexual harassment? What do you think? Basically, an employee of the landlord, one of the service personnel, used their pass key to enter the apartment, started rummaging through the underwear drawer, and then he starts playing with himself in his fiance's underwear. Was anybody sexually harassed? Nobody was home. It's not sexual harassment because there was nobody there. It is disgusting, though, but nobody was there. Did he do anything illegal? I would say yes. Because, here, let me continue reading. So, has the landlord and his employee sexually harassed anyone? Did he have the legal right to enter the apartment to begin with? Can a landlord enter an apartment without the permission of the tenant? The answer is no. They can only enter without prior permission in cases of emergency, like gas leaks or flooding. Otherwise, they're breaking and entering, and they could have criminal charges filed against them. Look, I remember one instance where I was a superintendent of an apartment building, and the guy right next door to me, there was a ticking noise coming from the apartment, and it was going on for about a week. Tick, 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 tick. You knock on the door, nobody's answering the door, nothing's going on. After a while, people started wondering, is the guy dead? Did something happen? I called the police. The police came out, they knocked on the door, said police and all that stuff. And I was like, well, I don't want to use my passkey to enter the door. That's why I called you guys, because I don't want to get in trouble for, just going into the guy's apartment. And they're like, well, yeah, we hear the noise, but are you just concerned that something happened, or is there an emergency going on, or is it just because of the annoying noise? What is it? And then they started hinting to me that, are you concerned that there's a dangerous condition in that apartment and that ticking noise could possibly maybe be a gas leak, and the stove is on and that it could possibly explode? I was like, yeah, that's it. He's like, okay, then use your pass key to go in. I was like, here you go. I opened the apartment, and then the cops went in, they checked it out. It was actually the weirdest thing. The guy was out of town on business, and he had a metronome, I think they call it. It's for musicians, it goes tick, 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 and you could set the speed of it to get a rhythm down, but he was using it to sleep better. It set some kind of the noise, at the speed that he had it on, it actually helped him sleep. That's what he said that it was for. But it was annoying as hell, because I heard, my bedroom was right next to him. I was in the apartment next to it, and it was just like constantly. I had to sleep on the couch. All right, so did that landlord's employee violate the law in any way? I say yes.
Yes.
I say, because did he have a right to enter the apartment? Unless he gave notice to the tenants in advance that they were going to be maybe doing pest control or inspections, or unless there was an emergency, which there was not, it's breaking an entry. Look, when you rent your apartment to a tenant, just because you're the owner of the building and you have a key maybe to the apartment, that doesn't give you the right, because it's your house, to come and go anytime you want. I had an issue like this with friends that were getting married, and they were going to be shopping. I was helping them shop for a new home, but in the meantime, they were renting, and their landlord sold the house, and they got these new tenants in that were from, I don't know, some foreign country, and this guy had this attitude. Well, they looked down on women, first of all, so he spoke very disrespectfully to his fiance, and he almost killed the guy, because the guy used his passkey to come into the apartment whenever he wanted to, and his fiance, she just got out of the shower. She had just a towel on. She came in, and the landlord's standing there in the middle of the apartment. She's yelling for him to get the hell out. He's like, it's my house. You don't tell me what to do. And oh my God, could you imagine? Yeah, yeah, absolutely. But they filed tons of complaints, but it wasn't really going anywhere. So we just had to get them out of there and find something for them quickly. But this is called a trespass complaint may be filed by the tenant with the local police department under the criminal code for defiant trespass. And here is the New Jersey statute 2A:39-6. Okay. Now, where did I get that from? I got it from the Truth in Renting booklet. You guys ever hear that Truth in Renting booklet? If you live in an apartment, in a building that has 3 or more rental units, not counting the unit that the landlord lives in, the landlord is required by law to provide the tenant with a copy of the Truth in Renting booklet and publish it in the hallways or in one of the general areas, open areas. But the laws in this Truth in Renting booklet apply to all tenants, even in buildings with less than 3 units. Here, let me share with you. This is the Truth in Renting booklet. I'll share you the link to that. Let me make sure that it works because I know they changed it last time. And I think I updated it here in the slide. So let me just make sure. Yes, I did. Okay. So this is what the Truth in Renting booklet looks like. I just opened it up from the browser. Okay. It's published by the Department of Community Affairs, and it deals with the tenants' rights and obligations as well as the landlord's rights and obligations. And it covers all kinds of issues from leasing to evictions, to entering the apartments, to having a satellite dish, to having service animals and all kinds of pets and all kinds of other stuff. And it provides all kinds of information about foreclosure, seniors, disabled, people who may, there's resources there for tenants that for if they need assistance with the utility bills and or legal help and all kinds of stuff like that. All right, so let's see what happened here.
Top story tonight, a Hoboken couple says their privacy was violated. Their bedroom security camera caught a maintenance worker going through their things.
But it's what they touched that has them still uneasy. News 12 New Jersey's Erica Such joining us in the newsroom with more on this story. Erica.
The couple tells us they purchased this security camera to just watch out when anyone was in their apartment, but never expected to capture an employee of their building going through their underwear. Take a look.
It said there was a notification for motion, so I checked it.
The Rivington resident Alex Sacchetti says he was at work just a few weeks ago when his security camera in his bedroom captured moments a maintenance worker did something out of the ordinary.
I started watching, and the man was, going towards the dresser. I was like, wow, that's strange. And then he opened it. He was going through my fiance's underwear. And, after I watched the entire event, there was potentially other lewd acts that took place, but mainly just going through my entire apartment.
The worker is seen checking the bedroom door, closing it, and turning off the lights before going into the corner of the room, blocked by pillows on the camera. Sacchetti says he quickly called management and alerted them. That's when this moment shows the man looking at the camera when he answers his radio call to leave the unit.
It was pretty much your whole privacy is violated.
Sacchetti says his fiance has been so upset by the situation, she's staying elsewhere for now. They filed a report with Hoboken police, but were told this.
He had the right to be in here, and apparently anything that took place is not a crime.
The two have been back and forth with Equity Apartments, who owns the complex, but says their responses have been lacking empathy.
There's been some outreach from some sort of manager or something, I'm not exactly sure. But as far as oversight or, hey, so sorry this happened to you, none of that.
And while this situation still leaves him uneasy, Sacchetti says it's a warning for others.
People here or elsewhere that have buildings should just have some sort of surveillance to fall back on.
And the couple tells us they're hoping to switch apartments in the near future. We did reach out to Equity Apartments for comment, but did not hear back. In the newsroom, Erica Such, News 12, New Jersey.
Yeah, this guy is way too laid back. I would have been like, let me speak to your supervisor. Where's your supervisor? To the police, they told him, they blew him off and told him they didn't do nothing illegal, that he had a right to be there. No, he didn't. Landlords and their employees do not have the right to enter your apartment just because they got the keys. When you sign a lease, what is a lease? Anybody know what a lease is? The actual legality of it?
It's an agreement between an individual and an owner.
Okay, but a lease sets the rights and obligations of the parties in this contract. It's a contract where an owner of real estate intentionally conveys their property to a tenant for a limited period of time as stated in the lease. It talks about how much the rent is and when it should be paid, but it's also where the landlord not just conveys the physical apartment to the tenant, but they're also conveying all of their rights. And we didn't learn about this. Yes, we're going to learn it in chapter 5. When you buy real estate, you get something that's known as the bundle of rights. These are all of your rights to keep others from entering your property. You have the right of possession. You have there's a bunch of rights. We call it the bundle of rights that you get. All of those rights are turned over to the tenant during the lease term, except for the right to sell the property, the right to to sell the property. But the landlord clearly violated the right that they gave them to enter the unit. That's why you're paying them, to be able to occupy and keep others from entering it. The landlord only has the right to enter for emergency reasons, or if they set up an appointment with you and got your permission to enter for like pest control or something along those lines. That's clearly not what happened here. This guy just used his passkey to come in and started rummaging through their drawers and such. How is that not violating the law? It is defiant trespass, as stated in that Truth in Renting booklet. That's where I got that actual code from. So if you actually look into the Truth in Renting booklet, let me see, where is it? Disposition, personal property, identity, habitat. I think it was on page 11 somewhere. Yeah, here we go. Right of entry. So go down to like page 11. I think the page numbers are off a little bit here though, but let me see. Security deposits.
Right there.
Yeah, right of entry. So I think we got to scroll down a little bit because it talks about, first of all, the landlord's right when a tenant has, kept the premises and they're not paying rent. But then here we go. A landlord shall be guilty of unlawful entry and detainer if they enter the rental premises peacefully or forcefully and then detain or keep possessions of the property or take property by the force or threat of force, or remove tenant's personal property without consent of the tenant or a judgment from a superior court in New Jersey. With the exceptions noted above, if the landlord enters a tenant's unit while the tenant is not home without the tenant's permission, it is forcible entry. If a tenant willfully or without force holds over or remains in the property after they've been given a written notice demanding delivery of possession because they're being evicted. Okay, now they're starting to get into something else. But here, this is if just in this sentence alone, with the exception of the above, if a landlord enters a tenant's unit while the tenant's not at home without the tenant's permission, it is a forcible entry. So it's basically breaking and entering, B&E. Then it goes on here, police actions. Okay, so any legal action for a forcible unlawful entry and detainer, forcible entry and unlawful detainer shall be brought before the superior court, and the court may hear and make determination of the action. I'm surprised the police did not know this. They either did not know this or they're covering for the big major developer that's bringing all the business and tax dollars into town, right? So if a landlord enters a rental premises unlawfully, a trespass complaint may be filed by a tenant with the local police department under New Jersey Criminal Code for defiant trespass. The guy should have known this. And that seemed like it was a big building there. So this should be made part of his lease, the Truth in Renting booklet. And he should have a copy of this. I guess he didn't look to it. He just went to the police. But if he did look in that booklet, he would see that they did violate the law. Okay. But it covers all kinds of other things too. Like, is the landlord required to have a key for the apartment? Is the tenant required to supply the landlord with a key? Or could they change the locks on the door? It depends what it says in your lease. There is no requirement under the law that the tenant has to provide the landlord with a copy of the key to the apartment. unless it says so in the lease. So if your landlord's here, just so you know that, you may want to read over this Truth in Renting booklet. All right, anyway. So, Attorney General's memorandum. Let's continue with, oh, maybe not. Oh my God. Where did the time go? Time is flying, my friends. It's already past 4:30. Did you know that? Sorry. All right, so let me give you the, I guess we're going to break this one over. Okay, so we're going to finish this chapter tomorrow, and then we're going to start picking it up. We're going to do, so we're going to finish 4, 5, do chapter 20, and then come back to 6. I don't know if we're going to finish 6, though. We're going to try to get through as many chapters as we can, but we got to pick up the pace a bit here, and we should. The first couple chapters are always slow for some reason. There's a lot of information there, but we'll start picking up the pace of these things. And once I find the poll, I'll share it with you. Okay, here we go. All right, and then you're dismissed. By the way, that link that I shared with you guys for your class videos, all these recorded classes, if you noticed, I just keep adding videos now to that link. If you notice, there's yesterday's class is already in there. You know, I just keep adding the videos as they're created to the to that playlist. Okay, so you'll have access to them if you want to replay them or get any information. You could get that. All right. And if you need the link again, it's also in the class links Word document. I updated that to have your class's link in it. All right, everybody. Have a good night. See you all tomorrow.
Bye.
You're welcome. Bye-bye.